Good morning, everyone. I hope everyone is having a fabulous Tuesday. So I found out that I'm not able to monetize these streams, which means I don't have to interrupt them every, too often to talk your ear off. So I am just going to let it play today. I do have to give you some information later on, but as of right now, here we go. And they do show the video multiple times, but for anybody who doesn't want to watch it, I give you a warning right before it happens. So this is day 2. Richland County, Ohio is where it took place. Montgomery County coroner is involved in it, and we are continuing with his cross-examination to start. I will talk, Griggsy. I'll be in the chat. Just out of curiosity, has anyone heard of the Indiana sheriff that was arrested this past week on major corruption charges? Because I just saw the stream last night and oh wow, it's nuts. So I'm going to work on that on my other computer while I'm chatting with you guys on this one, and let's do this.
Thank you, Judge. Good morning, Doctor.
Good morning.
My name's James Mayer. I'm going to ask you some questions on behalf of the defense here this morning. Just like you did earlier, if anything's not clear, ask us to rephrase and I'll try and ask a better question, okay?
Okay.
All right, so I kind of want to, some of this is going to be going over some of the same ground, of course. And so I kind of want to get back to the structure, starting out of the Montgomery County Coroner's Office, some of the responsibilities and that kind of thing, okay?
Okay.
All right, so how long have you been working at the Montgomery County Coroner's Office?
34 years.
34 years. You've indicated that you've testified as an expert how many times?
Hundreds of times.
Hundreds of times. And I suspect that because you all perform autopsies, not just for Montgomery County, but counties like Richland, that you testify, would seem all over the state.
Southern Ohio mostly, yes.
Southern Ohio. To that end, I'd like to approach you with what's been marked as Defendant's Exhibit A. May I approach, Judge?
Yes.
Okay. I'd like you to take a look at A, just for a moment, and tell me if you recognize the graphic that I've provided to you.
Yes, this is a...
Can you hold it up so the jury can see it with the court's permission?
Go ahead.
This is a map of Ohio, and there are colored in blue counties that we do the autopsies for in the state of Ohio.
And I think on direct exam you indicated somewhere 30 plus counties is the estimate?
Yes.
And it would seem as though that's consistent with that, right?
Yes.
You also indicated it covers most of the southern half of the state?
Yes.
And that also seems accurate, right?
Yes.
What's the red county there right in the middle?
Red
is that where
County
the most
is-
trouble is, or what is that?
That's Montgomery County.
Oh, I see. All right. So that's where you do all your work.
Yes.
All right. There's even one over here in what looks like somewhere outside of Ohio. What's that?
Wayne County, Indiana.
Okay. All right. So you perform autopsies for Wayne County, Indiana as well.
Yes.
All right. You indicated you've been there how long doing this?
34 years.
Are you a board certified forensic pathologist?
Yes.
Okay. Testified hundreds of times, you indicated. Generally speaking, when you get subpoenaed, it's by the state of Ohio, I presume?
Yes.
You also get subpoenaed by the defense from time to time, right?
Yes.
But ultimately, when actually raising hand and testifying, it's for the state of Ohio in your experience, yes?
Yes.
Okay. And in fact, you are here testifying in the state's case, correct?
Yes.
All right. In looking at the report that you signed back on November 22nd, 2019, do you have a copy of that in front of you? Well, we've got an exhibit
Yes.
that I think we can. May I approach, Judge?
Yes, but it looks like he has his own copy.
Okay. Would you take a look at State's Exhibit 1 and just see if it's the same? Actually, I think we'll just have you look at that and confirm that that is the report that you signed.
Yes.
Okay. You signed that down there at the bottom on November 22nd, 2019.
Yes.
And you signed that where your name is typed out. Also indicates Chief Deputy Coroner. Yes?
Yes.
Explain to us the structure. Who is the county coroner in Montgomery County?
The county coroner is Dr. Kent Harshbarger.
Okay. And that's an elected position, is that right?
Yes.
Okay. Yours is not.
No.
All right. explain to us how many forensic pathologists are working in the Montgomery County Coroner's Office at any given time, average, for Dr. Harshbarger performing autopsies?
Full-time, there are 6 of us, and then there are about 4 or 5 part-time.
Okay. And are all of them called chief deputy coroners?
No,
How many are?
just 1
And that's you.
at that time.
At that time. Okay. And at that time, that made you number 2. Is that fair?
Yes,
Okay. And so when you say that you discussed these findings that led to the opinion that we have had discussion about already here, and we'll have more on during my questioning, you indicated that that was arrived at based on a discussion between you and obviously Dr. Paul, right?
yes,
But you also named off a number of other doctors as well, yes?
yes,
And those would have been some of the other full-time forensic pathologists that you just mentioned were on staff then?
yes,
Okay. And also there would have been discussions with the guy's name's on the door, Dr. Harshbarger, right?
yes,
Okay. And collectively, after having reviewed all of the findings and the video, as you indicated several times, the determinations, the cause of death are what you mentioned, yes?
yes,
And that was at the time excited delirium, correct?
yes,
All right, we'll get into that in detail as we go on. You did not offer an opinion back in 2019 as to manner of death, correct?
correct,
And as I understand the testimony Tuesday from Dr. Paul and also your testimony earlier, that's because when any of these other counties in blue bring you a body for an autopsy, you will conduct the autopsy and make an opinion as to cause of death, correct?
yes,
But you do not make an opinion as to manner of death. You leave that to the coroner who is elected in the county where the death occurred.
yes,
Okay. And so you were asked, however, by Mr. Salisbury, if you had had the opportunity, or I suppose, for example, this all occurred in Montgomery County, you would have made a conclusion on manner of death and an opinion, correct?
yes,
And that opinion as to manner of death on November 22nd, 2019 would have been accident, yes?
yes,
Okay. And you indicated that that has everything to do with the lack of intent, right?
yes,
All right. A lack of intent to harm.
yes,
Now, you also were working in a teaching capacity at the time, correct?
yes,
All right. And that's sort of how Dr. Paul factors into this, right?
that is correct,
She was a fellow, which you have indicated is similar to a residency, right?
yes,
All right. And so it's a teacher-student relationship.
yes,
And I believe you indicated on direct exam, if there's ever a difference of opinion between teacher and student, the way the process works there at your office is the teacher opinion prevails, correct?
correct,
And that's just similar to any other teacher-student type relationship, right?
yes,
Okay. Now, I'm going to ask you some specific questions. I believe Mr. Salisbury for the state asked you if you ever recalled any discussion or disagreement between you and Dr. Paul in this case as to the opinion that she signed as to the cause of death being excited delirium, her opinion. Was there ever a discussion that you recall or a disagreement about that?
I do not recall any specific discussion. discussion.
All right. Well, she took it a step further when she testified, so I want to ask you this. Do you recall pressuring or otherwise ordering her over her objection, pressuring her to make this opinion of excited delirium?
No,
Did she ever come to you and say, why are you pressuring me into this, complaining or anything like that?
no,
Do you ever remember her sitting down in one of these roundtable discussions and laying out a detailed alternative theory to the excited delirium that she signed her name to?
no,
With respect to the video that you were asked extensively about, why doesn't the video, I believe the questioning went, why doesn't that we watch this video appear in the pages of this report? And it does not, correct?
it does not, and we do not
Please.
we do not put it in our report what we review, because we review a lot of things, medical records, police reports, EMS run sheets, we review a lot. We do not list them in our report.
And that's policy,
Yes,
every case.
yes,
Ordinary course of business.
yes,
Okay. So it's not an effort to hide the fact that she looked at the video and you all didn't want it to be in the report. That's not what happened here.
No,
How sure are you of that?
absolutely.
All right. Now, there is a system in your office that allows, whether it's you or one of the trainees, students, to indicate what they did review, right?
Yes,
And you told Agent Leonard about that in an interview that Mr. Salisbury referenced, didn't you?
I did.
And that was about 5 or 6 minutes explanation that you gave about how it is documented and reported that you did watch the video in this case and any other, right?
Yes,
Has to do with something called the limbs system, right?
yes.
We're not talking about arms and legs, right?
It's a computer system.
All right, tell us how that works and tell us how, in this case, that would have been documented that she watched the video, everybody else watched the video, and how it works generally. What's it for?
The computer system is a record-keeping system, and it keeps documents such as the autopsy report, the investigator's report, toxicology, and part of that system, record-keeping, is that the doctors can write notes when they do an autopsy, things that they find that may, or they perceive or could come up later. Like if there was a case in the hospital and I thought that the doctor had done something wrong, I would specifically say what I read and when I read it. We have that option. We do it. We don't in every case say every time I see a police report, I don't say I reviewed the police report. But when it's something that anticipate that will be of use later, it's put in there, and that's what happened in this case.
So there absolutely is record in the system at the Montgomery County Coroner's Office that the videos were reviewed, that the video was reviewed in this case.
Yes,
There's no cover up here.
yes.
To that point, you were asked questions about Bob Ball. Do you know Bob Ball?
I don't know if I actually met him. We talk on the phone a lot.
Okay. Now, as it relates to this case, you were questioned by Special Agent Leonard about whether Bob Ball is the one who started getting everybody at the Montgomery County Coroner's Office talking about excited delirium, as if he was influencing you to make that opinion. Do you remember Leonard asking you about that?
Yes.
How did you answer that?
No, that never happens.
Would anything like that ever happen?
No, it doesn't.
Well, why not?
We're consultants, and they're asking us for our opinion, and we would probably be highly insulted if somebody tried to tell us what we are going to find. He's an investigator, we're the doctors, we're the consultants, and I think we would have found it offensive.
Did any detectives from the Richland County Sheriff's Office come down there and tell you this is what we want?
No.
Would you find that offensive?
Yes.
If that happened, in this case or any other, Richland County looks to be about the furthest north on that blue. Do you think you would say we're going to turn that white?
I think we would have, yes.
Meaning you all wouldn't be doing their autopsies anymore, would you?
We would not.
All right. You indicated that Dr. Paul performed the autopsy, conducted it, right?
Yes,
Standard procedure that she would be able to do that?
yes,
And it was under your watchful eye, correct?
yes,
And you were in and out of the room as it's happening, right?
yes.
Okay. There were other people in the room as well, standard practice, and you can tell that if you need to refresh your recollection from your report,
Yes,
correct?
yes, she isn't alone. There's a photographer and there are usually several assistants. And, and it's not a one-person thing.
Assistants that work in the Montgomery County Coroner's Office?
Yes.
Are they also forensic pathologists, fellows, or something, I guess, maybe structurally below and on the totem pole?
They are, I think an analogy would be like a nurse-doctor relationship.
Gotcha. Okay. All right. And so they're also, in this case, and not uncommon, a representative from law enforcement was there, correct?
Yes,
And that would have been this Detective Radojcevic?
yes. I think that's what's in the report, yes.
Okay. We've also heard testimony that an agent from BCI stopped in at some point. Does that sound as though something that would be normal?
BCI almost always accompanies a case, suspected homicide, or a case from any other county. BCI usually gets involved and it will come to our office in accompany case.
Nothing uncommon about BCI being involved?
No, that's pretty routine.
And like you told Special Agent Leonard, they're welcome to come whenever they want, right?
Yeah, we do. We don't have any rules.
Right. And so when the autopsy is being conducted, this is the table here, right?
Mm-hmm.
And you've got Dr. Paul working, just generally, the people who are observing, right,
Yes.
in this circumstance, the law enforcement types, they're just actually in the room, right?
Yes.
So they're not like we see in some movies or things like that behind glass or up in a balcony or something like that, right?
No.
They could be as close to me and you
Yes.
if you're performing.
Yes.
They can hear things like conversations going on.
Yes.
Not uncommon for the forensic pathologist that's performing the autopsy to make some comments to assistants and or law enforcement during the process, right?
That is not uncommon.
And generally speaking, it would be common for the person performing the autopsy to say things that are of note.
Yes.
Take note of this, this is what I see here. All things that might be relevant later to cause of death, yes?
Yes.
Okay. And in this case, there were several of those things to talk about during the autopsy, right?
I wasn't there, but I'd agree with you.
Okay. Now, you mentioned the photographer. Photographer in every autopsy?
Yes.
All right. Special Agent Leonard wanted to ask you about the photos in this case. Do you recall that?
Yes.
And he said, well, there were only 18 pictures taken. Do you remember that?
Yes.
All right. Is that out of the ordinary to have just 18 photographs taken of an autopsy?
No.
Is there a number that you have to take?
No.
What's the standard?
In our office, we take what we call standard photographs, and we photograph the condition the body is when it arrives at our office. The clothes, medical equipment, whatever is on them. And after we document that photograph, then we describe what we see. The body is disrobed, the body is washed, and then we photograph the body from the right side, the left side, the back, and we take pictures of the face. We take standard pictures that pretty much document the entire skin surface of the body to show if there are injury or if there isn't any injury. And then during the autopsy, if there's something injury related to damage to the lung, damage to the liver, or kidney, damage in the neck or anywhere in the body, if there is an injury or some significant findings, we'll photograph that. If there are not, there's no injuries there, there's no damaged lungs or heart or whatever, there just aren't that many. We don't take pictures. We don't take a lot of pictures of normal.
Don't take a lot of pictures of normal.
Yeah.
Right. So you're not in there just taking pictures to take them.
Yes.
So it stands to reason that a person who has a more unremarkable examination during their autopsy, there'd be less pictures, right?
Yes.
All sorts of injury and different things of note with respect to abnormalities. You could have many, many, many pictures, yes?
Yes.
Okay. And so as it relates to the 18 photos that were taken in this case, you've reviewed them, correct?
Yes.
Consistent with the findings as to what was photographed?
Yes.
All right. And we'll talk about some of the photographs that were taken that were of consequence or of note in this case, okay?
Okay.
In a little bit. All right. So I want to kind of get right into the report itself, okay? The report appears to be broken down essentially almost conclusion first, and that's page 1, right, with opinion?
Yes.
And some of the accompanying underlying relevant pieces of information that lead to that opinion. Is that fair?
Yes.
Okay. And then from there, beginning on page 2, you just kind of get a head-to-toe examination starting with the external and then progressing to the internal organs. Is that fair?
Yes.
Okay. And then the last portion of that is what has been described previously as a toxicology report or a lab report, right?
Yes.
Okay. All right. So I want you to confirm some of these things for me. The report confirms that Mr. Rios, upon his arrival, was 5'10" and 194 pounds. Yes?
Yes.
Appeared generally fit?
Yes.
Okay. Aged, according to the report, 28-year-old white male.
Yes.
Okay. Talked about the number of photos that were taken. If you need to, as you take a look at the report, during the external examination, there is discussion about the eyes. Can you get to that portion?
Okay, my hearing isn't good.
I was looking down. There's a discussion about the eyes and the examination of the
Yes.
eyes and also the mouth. I want to start with the eyes. It's on page 2. Looks to be second paragraph under external examination. Let me know when you're there.
Yeah, I'm there.
Okay. So we're talking about the eyes when we talk about the sclera and the conjunctivi as being unremarkable.
Yes.
What does that mean for these folks?
There's no damage, no injuries, there's no evidence of disease.
Okay. We go on to talk about the eyes being free of petechiae. Can you give the jurors a definition of petechiae?
Okay, petechiae are small hemorrhages, little red spots. But what has happened, the capillaries, real small vessels capillaries would break, and they show little, basically red dots in the sclera and the white and around the eyes. And that's what she's describing, that they weren't there.
That they weren't there.
Yes.
And so if they're not there, are we going to take a picture as standard procedure so that we can say they're not there?
Generally, no.
Because we don't photograph normal, is that right?
Yes.
Okay. Petechiae show up in other areas as well sometimes in autopsies, yes?
Yes.
Where else can they show up?
Actually, it could occur anywhere, but often in the face, particularly around the eyes, inside the mouth, oral mucosa, in the throat, on the larynx, epiglottis, that area.
All of those areas were examined by reading through this report, correct?
Yes,
And there is no mention of the discovery of any petechiae in those areas either, correct?
that is correct.
Okay. Now, for purposes of discussion, petechiae are relevant to note in certain types of cases. Well, they're always important to note, but what relevance do they have when it comes to your line of work and what sorts of determinations you can make based on presence of petechiae in any of those places?
Okay, petechiae are a sign of an asphyxial death, but particularly if there's like strangulation or if there is a compression asphyxia, like we're talking about in this case. What happens is the blood pressure that's in the chest or blood pressure if you're closing off your neck rises in the capillary. When closing off the neck, it's because you're stopping the blood from returning through the jugular veins. So the heart is pumping blood up into the face. It can't escape through the jugular vein when you're compressing the neck, and then the capillaries break. A similar thing happens when you're putting a lot of pressure on the chest. The pressure in the chest is now going up through the veins into the face, and then the capillaries break and we get those small dots that you're referring to.
And that pressure on the chest can be either on the front portion, I guess, of the chest, or pressure on the chest from behind.
If it's being compressed.
Yes. And so someone in a prone position who's having pressure applied to their back could exhibit petechiae.
Yes,
And in this case, we have no evidence of that.
correct.
Relevant to you when you were making some of the determinations that you made in this case?
It's relevant, but probably disappointing to you that the problem is they don't stick around. So we're examining the body a week. He's been in the hospital for a week. And in that time, they can resolve. And it's entirely possible that they were there. And by the time we got the bodies, they have resolved, they're gone.
Okay. No evidence from any of the hospital records that they were present.
That is correct.
Okay. And so can resolve over that period of time suggests potentially not resolve either though, right?
Yes,
Fair. Okay. I want to talk about the examination of the neck. There was both an external and an internal examination of the neck, correct?
yes,
With respect to the external examination of the neck, there was nothing unremarkable.
yes. There was nothing to describe, yeah.
Examples of remarkable would be any type of discoloration as a result of bruising, correct?
Right,
All right. And in fact, there were no bruises on the anterior or the posterior neck, correct?
that is correct.
Nor on, I guess, the sides. Is that a technical term?
No, there were no bruises.
What are the sides? What would we call that?
The sides.
All right. All right. And this would be anterior,
Yes.
posterior back here, anterior hip.
Yes,
All right. One word. All right. So also the internal examination.
yes.
How does the internal examination of the neck occur and how did it occur in this case? Do you need to refer to your notes to help you?
Well,
To your report?
I know it's in
Yes.
the report. I didn't actually witness, the exact procedure. I may have, but I don't recall the exact procedure that was used. But in every case, we're taking up the skin, and we're examining the muscles, and we're looking for fractures of the hyoid bone. We're looking for damages to the carotid arteries, the jugular veins, any bruises in any of the muscles.
Internal bruising.
Yeah, that's part of every autopsy.
Sure.
But I didn't know the exact procedure, or at least I don't remember the exact procedure that was used in this case.
When you talk about those muscles that you're looking for internal bruising, are those called strap muscles?
Yes.
What are the large vessels that are also mentioned alongside strap muscles?
Okay, am I hearing bad again?
Are the large vessels the carotid artery and so forth?
Oh, yeah, she's referring to the jugular vein and the carotid artery.
Okay, and the strap muscles are the surrounding support system?
Yeah, those are what turn your head and lift up and down.
No abnormalities, no internal bruising noted with respect to that internal
Yes.
examination.
Yes,
Hyoid bone and the larynx were both deemed to be intact and uninjured.
yes.
Show us where those are.
Well, the hyoid bone is right here. It's it's what your tongue is kind of attached to, and it's squeezing on the neck. That could fracture. That's a fracture of the hyoid bone would be a fracture, injury we'd see in somebody strangled. Okay, I forgot the rest of the question.
No, that's fine. With respect to the examination of those two areas, the hyoid bone and the larynx, both were intact and uninjured.
Yes,
Okay. It also indicates there were no tongue contusions.
yes.
What's that mean?
But he didn't bite his tongue, basically. Bruises in the tongue usually happen when somebody's biting the tongue. It could happen in an altercation, but the most frequent time we see is somebody bit their tongue, and it's most often in a seizure or something like that.
Okay. And there was nothing to support any of that, no damage to the tongue, correct?
Correct.
Okay. The back was examined as well, correct?
Yes,
The examination of the back was, quote, unremarkable.
yes,
Okay. From that, we can conclude that his entire back had no bruising.
yes,
Okay. Now, when we're talking about the distinction between pressure in a compression situation,
yes,
okay, I heard you drawing a distinction between length of time and how much pressure, right?
yes,
Okay. And so you talked about studies where people have weight vests loaded up with 250 plus pounds to see how
225 pounds. I
225.
said 250, I was wrong, 225.
225 loaded up, and findings you can make based on that. People being able to breathe and
Yes.
not being life-threatening and so forth, right?
That's what the experts said.
Certainly stands to reason that at some point there's enough weight you can put on someone's back where they're not going to be fine. Is that fair?
Yes,
Okay. And when you have that, you can have actual injuries that are associated with that, correct?
yes,
You were asked questions about the mechanism of breathing, right?
yes,
It's the rising and falling of the rib cage, the muscles in between, and the diaphragm that help with that process. Is that fair?
yes,
Okay. In a compression injury, if there is enough weight placed on the back of someone in a prone position, there's nowhere to go at that point, right?
yes,
You can have broken bones like broken ribs or fractured ribs, correct?
right,
Are you familiar with the condition flail chest?
yes.
What is that?
Flail chest is when all the ribs on both sides are fractured, usually toward the front. And when that happens, if the patient tries to breathe, the chest goes in. There's no way to expand the chest. And if they try to breathe with their abdomen, the same thing happens. The chest caves in because it's movable. The chest has to be somewhat rigid for basically a vacuum to form to pull air in so that people can breathe.
Right. So that would be an example of when a person's in a prone position and weight keeps getting loaded on top of them, the weight's not going to give, eventually the body can give, right?
Yes,
And that can be evidenced by fractures.
right,
It can also be evidenced prior to that by bruising, yes?
yes,
All right. And to be clear, in this case, in the examination of Mr. Rios, there were no injuries noted whatsoever to his back.
That is true.
Okay. One thing that was noted was kidney stones, correct?
Yes.
Okay. And that might have been something that was discussed, not as it relates to his death,
Yeah.
but
Yes.
as an interesting finding.
Yes.
Okay. Let's talk specifically about evidence of injury.
Yes.
Okay? This paragraph can be super long or it can be real short, right?
Yes.
In this particular case, the injuries would best be described, evidence of injury would best be described as minor, yes?
Yes.
And certainly non-life-threatening.
Yes.
Spray a little Neosporin and a Band-Aid maybe, right? Abrasions.
Yes.
Okay. And there were 4 of them noted, all ranging in 1/4 of an inch to a 1/2 an inch on different areas of your body, of his body, and Dr. Paul testified to those already. Do you agree with those?
Yes.
Okay. Now, I want to get to what was the subject of so much of your testimony earlier. Okay. As you were making your opinion, you indicated that with respect to 2019 and the opinion of excited delirium as the cause of death, you described it as a syndrome, which is characterized by a pattern or a group of findings, right?
Yes.
And we'll get into those in a moment. But in explaining that to the jury and also to Special Agent Lenhart, you indicated that the syndrome has to be brought on by something,
Yes.
right? And what you really mean is the delirious state, right?
Right.
Which is still a thing in 2023, as I understand your testimony.
Yes.
We just not going to call it excited delirium anymore.
We can't use that word.
We're going to show our work, and we're going to give you all the group of findings that would support delirium,
Yes.
but we're not going to call it that.
We're just changing the name.
Doesn't make it any less of a thing, though, right?
No, it's still there.
But it is unusual and it is uncommon, right?
Yes.
But it's brought on by something, right?
Yes.
And you have opined back then, right, and today, that you believe it had to do with methamphetamine intoxication,
Yes.
right? Methamphetamine psychosis is a thing, right?
Yes.
All right? And it's a delirious state, right?
Yes.
And it's characterized by a number of things, right?
Yes.
We'll get to those. All right. Now, in getting to that opinion, you were challenged on the idea that, whoa. The hospital test doesn't say positive for methamphetamine. It says presumptive positive for amphetamine. Remember that?
Yes.
And you said, yes, that's true, right?
Yes.
But you also indicated that the threshold, the cutoff, has to be a significant amount of amphetamine to make it into that panel to be a presumptive positive, correct?
Objection.
Basis.
He said he didn't know what the cutoff was.
Whatever the cutoff is.
If you can answer, if you know, you can answer.
I don't know what the cutoff is,
Right.
but
You know that there are cutoffs at hospitals.
Yes.
And you have a familiarity that whatever the cutoff is, it's consistent with what?
it's a significant level. The doctors don't want a lot of false positives. They don't want to try to treat something that is not significant.
Right. And certainly, and in a urinary screen, you're not going to get presumptive positive for methamphetamine, right?
No.
What you're going to get are something that would be a component of methamphetamine.
In the same class.
Same class, yes. And that would be the amphetamine, right?
Yes.
And that's a stimulant drug?
Yes.
Okay. And so you concluded that presumptive positive was one of the factors that led you to believe that Mr. Rios was suffering from methamphetamine intoxication, right? One of the factors.
Yes.
There were others, right?
Yes.
One of the peculiar findings, perhaps unusual, you tell me, was the examination of the stomach of Mr. Rios, correct?
Yes.
You were not asked about that, were you?
No.
Okay. But that's documented in the report, what was located in his stomach, correct?
Yes.
All right. And what was located in his stomach was a small plastic bag-like object that was ruptured or torn, correct?
Yes.
And that was significant enough that it was collected by Dr. Paul, yes?
Yes.
And it was provided to law enforcement right there at the scene, right?
Yes.
For evidence,
Yes.
right? And that happens from time to time, right?
Yes.
But not all the time.
No, not all the time.
All right. So anything that might be relevant to the investigation as to anything else that law enforcement was doing if it's located during the autopsy, protocol would be to allow law enforcement to collect it.
Yes,
And that's what happened in this case.
yes,
All right. Now, referring back to page 1, which is the opinion page, you have Roman numeral 1 at the top. You see that?
yes,
You indicate sudden collapse, signed off on sudden collapse, your opinion, following excited state and physical altercation with law enforcement, correct?
yes,
That speaks directly to the physical altercation with law enforcement, right?
yes.
You're not ignoring that, right?
No, we're aware of that.
Right. So much so that it's in the first sentence that you put on the opinion page that happened, right?
Yes,
Okay. And that physical altercation with law enforcement is almost a hallmark of excited delirium, restraint-based interactions, right?
yes,
Okay. Now, you indicate Roman numeral 1, first letter A, torn, ruptured plastic bag-like object in the stomach, yes?
yes,
And then right after that, you move into section B, which is the urinary drug screen, positive for amphetamines following hospital admission. In your opinion, are A and B1 connected
yes.
in making the determination for excited delirium?
We're not relying entirely on it, but we're using that as further support. That
What
diagnosis.
relationship, just so we can just give it to them straight, what relationship does the locating of the plastic bag ruptured, torn object in his stomach, how does that dovetail, if it does, with the presumptive positive for amphetamines in this case?
We do thousands of autopsies, and prisoners, once they're arrested, occasionally, shortly after they're arrested, die of a drug overdose. And for the most part, they're not getting the drugs in jail. What is happening is if they have drugs on their body by the time they're being arrested, in an effort to hide that evidence of the drugs, they swallow it.
And so you've seen this before,
Yes,
and it has in the past led to overdose deaths in your experience.
yes,
Okay. And so the location of that evidence in the stomach dovetails with the presumptive positive for amphetamine when you were making the conclusion of methamphetamine intoxication, right?
yes,
Of course. Just common sense based, yes?
yes,
All right. And it's also consistent with your experience in drug overdose deaths, right?
yes,
All right. Now, a lot of discussion was had with respect to what the floor could be on a presumptive positive, right?
yes,
Okay, when Mr. Salisbury is asking you questions. And that's fine. We'll get to what the threshold cutoff is. And you've told us what those are in general. Because we don't have a confirmatory test, that test would not just tell us, right, like hospital blood, would tell us not just specifically what the drug is, but it would tell us levels, correct?
yes,
And so, stands to reason that because we don't have that confirmatory test, we could be dealing with a astronomical level with respect to the methamphetamine that was consumed, if that's in fact the case, correct?
correct,
All right. And it stands to reason that the more methamphetamine you ingest, the more erratic and psychotic your behavior can become, correct?
Objection.
If you know.
I think we're confusing actually two things.
Please.
There's,
Thanks for correcting.
you can have reaction to methamphetamine the way you're describing as an overdose. Or, in this case, a reaction that's causing a syndrome.
Sure.
And I think you're mixing the two together.
Fair. What I'm getting at, to be clear, is we can't tell from the presumptive positive. We know what the basement is on what that threshold cutoff is on the amphetamine presumptive positive, right?
Okay,
What we can't tell is what the absence of the confirmatory test can't give us what, in the absence of that, we can't get the level, right?
that is true.
And that level certainly could be at a toxic level, correct?
Yes,
Okay. Toxic meaning potentially causing death.
right.
Okay. Are you familiar with what the toxic level is with respect to, if you know, methamphetamine?
There isn't like one level. So, and the question comes up a lot. If, I even can't give you enough, if there's a significant amount and then you have nothing else, it could be maybe 100 nanograms and maybe 1,000 nanograms. If that amount of methamphetamine is in the body and we have no other reason to explain the death, then will contribute to death to methamphetamine. But there isn't one level that we know will kill you and a safe level below that will not kill you.
Okay. But certainly the greater the level, the greater the risk.
Yes.
Okay. All right. And so the last piece to this, as far as making the determination or the opinion that methamphetamine intoxication plays into the excited delirium and the condition that Mr. Rios was exhibiting, is his behavior, right?
Yes.
Okay. And so when you talk about the syndrome, which is a group of findings, you have testified this morning that it is hallmarked by an acute confusional state. Yes? All right. What I'd like to, where someone without warning sort of goes from being relatively normal to disoriented. Is that fair?
Right.
Okay. These people that are exhibiting this pattern of findings also typically combative. Yes?
Yes.
They also display extreme agitation.
Yes.
They also can exhibit increased strength, I believe you told Officer Leonard.
Yes.
And that's consistent with your experience and expertise and training with respect to excited delirium and now the pattern of findings that would go along with that.
Yes.
Okay. And they also can prove to be difficult to restrain.
Yes.
And I would assume that that has to do with everything that just came before that put together.
Right.
If they're combative, if they're disoriented, if they're confused, and they're exhibiting increased levels of normal strength, then that's by definition going to make it more difficult to restrain someone like that, right?
Yes.
These people are probably also experiencing some degree of natural adrenaline as well, right?
Yes.
Okay. And adrenaline is what people think of, right?
Right.
It's like people that are in a stressful moment. You hear stories about people being able to like lift the back of a car. I mean, they're anecdotal, but things like that, right?
Yes.
All right. People that have adrenal moments and maybe even this excited delirium, they can have dumps at the end of them, right?
Yes.
Okay. Now, so when you put all of that together, when you're talking about something has to trigger the delirium, right?
Yes.
And you're pointing to methamphetamine intoxication, what you indicated to Leonard is what you've told this jury today. You have hypothesized or opined that it seems that this individual ate a bag of methamphetamine that led to this, right?
Yes.
Okay. And so you've got the presumptive positive for amphetamine, the behavior, and the bag in the stomach. And that was the information that was available to you back in 2019 that caused you to conclude that the triggering event for the delirium was in fact the methamphetamine ingestion intoxication. Yes?
Yes.
Okay.
What's his last name?
Rios.
Rios, I need you to come down so we can.
Okay.
Alright.
All the law.
Alright. I'm not gonna call anybody unless you come down from down here. Okay, this is the last time I'm gonna ask you. I've asked you for like 5 minutes. I'm not gonna do it anymore. Okay? We're gonna put you in.
All right. Now, during direct examination, before they put that video up there, they asked you questions to explain how he appeared to be acting confused. And you gave examples of, well, he's speaking in confused manners, he's shouting, things of that nature, right?
Right.
Okay. When we pause it, all right, where was he standing?
He was standing on a short wall.
Yeah, like a short cement half wall, right?
Right.
All right, and he's wearing what amounts to a green suicide type suit, right?
Yes.
All right. Now, if I took a break here and climbed up on this half wall and started asking you questions, but instead of that, just started saying, I'm not supposed to be here, call the law, would it be your opinion that I'm acting in a confused state?
Yes, it would.
It's common sense, right?
Yes.
Objection.
I guess sustained.
All right. I'm not going to do that, okay? But when we talk about evidence of a acute onset of a confusional state, that's evidence of that, right?
Yes.
Okay. And keep playing.
Straight care for your safety due to not listening and being uninvited, causing a risk to harm yourself. We don't have time to continue that all night. Okay? All right, this is the last time I'm asking, and we're gonna go ahead and put you in the chair.
Why didn't you just open the door?
All right, come on down. No?
Handcuff.
Is that a yes or no?
I'm supposed to.
Go ahead and turn around, put your hands behind your back.
Stop.
Cuff up.
Do you see Mr. Rios looking around up in the ceiling and trying to look up here for things?
Yes,
All right. Also evidence of some confusion there perhaps as you're watching the video?
yes.
All right. Keep going.
Foreman, if not, we're gonna come get you. All right.
You got
No.
it wrong, man.
Okay, we're coming to get you.
Ready?
Let's go. Go through that. Hands behind your back here.
Pause. All right. So you indicate that a person that is exhibiting signs of the pattern, delirium, that they appear agitated,
Yes,
sometimes extreme agitation.
yes.
Agree he seems agitated, if not extremely agitated, as he's in there and as he bursts out of the cell through the COs?
I agree.
Okay. You indicated that people exhibiting pattern of the syndrome are combative,
Yes,
running through the COs and around the booking area and then wrestling with them. Is that what you see here?
yes,
Evidence of combative?
yes.
Okay, please continue.
Come on, man. I'm ready to fight. Here's your taser.
Pause. You see evidence of Mr. Rios up to his knees and starting to raise to his feet there?
Yes,
Okay. You see a number of individuals in black uniforms, corrections officers at that point?
yes,
Fair to say that all four of them at that point are struggling and using their body weight to try and gain control of him.
yes.
And this all is occurring as he is wrestling with them, correct?
Right.
Please continue.
Crazy. No, take it off. Taser. I'm not even playing.
More wrestling? Okay, we just heard a taser there, right?
Yes.
Now, talk to us about a taser. Something that you have familiarity with at the coroner's office?
Some, but I'm certainly not an expert on tasers.
Okay. But you know that it is an electronic stun device?
Yes.
All right. What else do you know about it? Just
Creates a painful shock. Yeah.
the idea is to bring compliance with that, right?
Right.
Okay. And it does so by causing pain to the body of the person that is tased.
Yes.
And that puts a toll on the body, correct?
Yes.
All right, please continue.
Last week I got them glasses. Taser.
You see more tasing going on there?
Yes.
Please pause. At this point, we see more corrections officers. You can kind of see the head of an individual here at the top of the screen. Do you see that?
Yes.
It was described by Mr. Salisbury that all the other corrections officers during this attempted restraint were holding on the limbs of Mr. Rios. Just watching the first minute or two of this restraint, would you agree that it seems like many COs are putting their weight on Mr. Rios?
I think I can agree with that. Yes.
He's in a prone position, correct?
Yes.
We do not see any foot on the upper back area at this point, do we?
No.
Instead, we can see this officer who appears to have his body behind. That would be his weight on top of Mr. Rios, correct?
Yes.
Just a portion of it.
A portion.
We have this corrections officer laying completely across, putting pressure on Mr. Rios' head, correct?
Yes.
And we also have tasing going on during this time.
Yes.
And then from this video, we can't tell what the other corrections guys are doing, right?
I agree.
Okay. But we can tell it's a collective effort to try and get him restrained, right?
Yes, it is.
Okay, please continue.
Can someone tasing? Can you explain to me? Because you're a dumbass.
All right.
Now here's the dumbass.
Pause, please. And I believe now at this point we do have pressure being applied to the back area, upper back area of Mr. Rios. Would you agree with that? Did you see
Yes.
it? Okay. And so to be clear, when you were answering the questions about amount of force and that sort of thing, right?
Yes.
It wasn't so much about length of time to you as it was how much pressure is being applied, right?
Right.
And the only time during this entire video that we can make any determination as to the individual who gets up on both feet, applying all of their body weight, is during that 7 seconds when that happens, right?
Right.
Every other moment that any pressure being applied by anyone, and it's just clear that there's a lot of people applying pressure intermittently to Mr. Rios, correct?
Yes.
And not just his limbs, right?
That is correct.
Right. And so the only time that we can tell how much pressure is being applied by the individual who gets up on both feet is during those 7 seconds, right?
Objection.
Based on what he sees on the video, if you can answer, if you know.
That's all I see, yes.
Yes. And so right now, when that foot first goes up on the shoulder area, we can't tell how much weight is on this leg and how much is brought to bear on the foot that is actually on Mr. Rios' shoulder, correct?
Correct.
That's an important thing, an important vital piece of information that you simply didn't have available to you and can't have available to you when you're making your determination, correct?
That is correct.
Right. And if I understood your testimony, it's one of the reasons why your answer is, I can't tell what the actions of the officer who lifted both feet up, what role that had with respect to the death, right?
That is correct.
Please keep rolling.
Didn't say you were hurt. Oh,
Thought he took out on himself.
really?
Yeah, he's like,
Oh! Ah! Get your hand behind your back.
oh shit.
Somebody take it.
He's on some type of, I believe.
Keep playing.
Please pause. Back it up, the 10-second little loop there, Sean. Okay, roll it.
Somebody take it.
He's on some type of,
Pause. We can see the green suicide smock here, would you agree?
Yes.
Here, it's just all black, right?
That is correct.
And this is on what would be the mid to lower back area, right?
Yes.
This would be the weight of another corrections officer on his mid-low back, right?
Objection.
If you can tell, based on the video.
I don't know.
Right. Stands to reason, right?
Yes.
Again, only if he's able to make a conclusion.
Fair to say, it's difficult to make a conclusion because it's a sea of bodies wearing black that are all crawling around on him, right?
I agree.
Okay, please continue.
I believe.
Keep playing.
You need to.
Pause. During this time, you can hear Mr. Rios communicating in some ways with the corrections staff, right?
Yes.
There's that period where there's the dialogue about who's a dumbass and the confusion and who caused this and all of that, right?
That is correct.
He's also making some yells and things like that, right?
Yes.
All indicating that he's communicating things like that he's breathing, right?
Yes.
Okay. At no point in time during the time he's communicating does he at any point say, I can't breathe. You don't hear that on the video.
I did not hear that.
Okay, please continue.
Do we have anybody else available?
I thought this was good.
Rios? Rios. Alexander Rios.
That's the one that was supposed to go on last night, wasn't it?
Yeah, he thinks he's supposed to be out of here and he didn't get out on the wall.
It's during these 7 seconds that you know that that full 250 pounds or whatever gentleman weighs at the time, right?
That is correct.
Okay. And now he's back down.
Yes.
So we go back to not knowing how much pressure is being applied
Yes.
by him.
Yes.
Okay, please continue.
Come on. Let go of the car. I'll fucking. Let go of the car.
Pause. Some 15 seconds or so after the individual gets off at the back, his full weight, you were questioned about there's no meaningful movement after that or something to that effect.
Yeah.
Did you hear the officer indicate twice, let go of the cuff?
I think that's what I heard.
Okay, would you like to hear it again?
I don't really want to hear it again.
Okay. But you think that's what you heard, right?
Yes,
Right? The officer's instructing the individual to let go of the cuff, right?
yes,
Suggest meaningful effort and movement by Mr. Rios, right?
Objection.
If you know, if you can make that opinion.
it suggests that, yes.
Okay, please continue.
Right up there on the wall.
Pull that thing out and come out.
Get a pair of shackles.
We got another hit, can you come? Where's the other hand? I got it.
You hear the CO still talking about getting shackles and getting handcuffs, correct?
Yes,
You want a pair of shackles?
Okay.
Somebody get beside
me. Get up. Alright.
Grab some, oh, he's got them. We got shackles.
Ready?
All right,
Yeah.
shackles.
Give me the other hand. Bring me forward from guys. You got it?
Shackle them down there.
This glove.
Those are too big?
You know, second. Where's the latest?
Think that's gonna be too big? Let's find this foot up there?
Who's that?
Right.
Okay. Cinch up around the ankle. Do his ankles now, so. Keep going. Yeah, come on the other side of the wall. When we come up, we're going straight up into the chair. All right. Cooper, I'm behind you. And Laura behind you. I got the chair so it doesn't move. Okay. You two ready? Just turn. Straight up.
All right. Thank you for going back through the video and answering my questions on that.
okay,
All right. And so that is the video that you watched several times before you ever put pen to paper on this video, correct?
that is correct.
And you've had an opportunity to answer questions this morning for the better part of, I'd say, 2.5 hours with a little break in there.
Yes.
As to how you arrived at that opinion. You recall
How
that?
we arrived at co-
You had questions, you had an opportunity to answer questions all morning about how you arrived at that opinion, correct?
Yes,
Okay. And so as you sit here today, you can confirm that your opinion back then was excited delirium, correct?
yes,
You also confirmed that had you been given the opportunity, had it happened in Montgomery County, the manner of death, in your opinion, would be accident.
yes,
The same autopsy was conducted today, subsequent to the changes with respect to how NAME wants you to describe excited delirium now, okay? How would you describe the death as cause of, how would you describe the cause of death today?
we can't use that term. And what NAME endorses is to put the cause of the delirium down. And we know there is a stimulant drug, so it would be a reaction to a stimulant drug, probably or possibly methamphetamine, causing a delirium or causing a fatal delirium, something to that effect.
Okay. And then leading to what, as far as the pattern with respect to the delirium, leading to what did that cause? The methamphetamine intoxication.
The methamphetamine intoxication is causing the delirium, which results in death.
Right. Okay. And so is your opinion changed today as to cause of death?
No,
Okay. Despite all those questions by Mr. Salisbury.
it had not changed.
Okay. Now, what about manner of death? What's your opinion on manner of death today?
Accident?
Same as it was in 2019, same as it is today in 2023.
Yes.
One moment, please.
Sure.
Okay. And I think I need to ask you this question to sort of finish the conversation. Once you cite all those indicators as far as the pattern for the delirium, the methamphetamine intoxication, all of the things that we've been through with respect to the onset of confused state, combative, all of that, increased strength. Once you cite all of those things, do you then get to the conclusion that it was all of those things that brought on the anoxic encephalopathy?
No.
Then explain to us how we get there.
He had a cardiopulmonary arrest. His heart stopped. He stopped breathing. And then he had CPR, maybe 15, 20 minutes, whatever it took to his heart start beating again. Now, during that time, he's not getting enough oxygen to keep his head alive. There's a period of time after he stopped breathing before he start CPR, and even with very good CPR, it is not unusual that the patient ends up with damage to the brain and anoxic encephalopathy. And when that happens, they end up on a respirator because they can't breathe, and eventually they die of respiratory failure. Because they can't breathe on their own, they can't keep enough oxygen going to their heart, and the heart stops. So I think that's what you're referring to.
Yeah, and so if I understand, that becomes a byproduct of the cause of death that you've described.
Right.
No other questions, thank you.
Follow-up questions, Assistant Prosecutor Salisbury?
Thank you. If you photograph all the important things, why didn't you photograph the plastic, what is noted as a plastic bag in the stomach?
It's photographed.
In your photographs?
Yeah, it's photographed. I would think you would have them.
Okay. Well, I would too. You know that you don't know what that is, what that object is, that it's been, since Mr. Mayor brought it up and he correctly pointed out that I didn't go into that, but he did, you know that that has been tested at BCI and you cannot determine that that is in fact a plastic bag, correct?
Correct.
Okay. And you know that it did not test positive for any drugs, correct?
Jack can ask you the approach.
Yeah, come on up.
If you are a juror on the mock trial case, please use this time to go to the restroom, go make a sandwich, take the next 6.5 minutes and go do something away from the computer, mute your computer. I don't care, but do not listen to the next 6.5 minutes of this hearing.
This is
Thank
anything
you.
that's on the record, like we're on the record now, that's totally fine. It's stuff that's, when we're not on the record, I want to make sure we're not recording prosecutor conversations with a witness that are off the record, or defense counsel discussing the case with their client on a break. I don't want that to be obviously live stream. So it's, when we're on the record, I have no problem. It's off the record stuff that I'm concerned about recordings. Is there any issue with that from your perspective? No. Okay, you're shaking your head. No. Very good. Thank you. Well, the jurors have left. We're still on the record. Do you want Dr. Lehman? Can he go, or do you need him here?
I don't think we need Dr. Lehman for this.
Okay. Dr. Lee, we're going to let you have a lunch break, and we'll come back. And I appreciate you staying over lunch. I would like to finish you up, but there's some stuff I got to do that might take some time. Thank you, Doctor. We're going to let you take your lunch break, too.
All I'm going to do is ask him.
So what we were talking up here, and I didn't want to have the discussion in front of the jurors, was about the question being asked of Dr. Lane was whether he knew that the item taken from Mr. Rios' stomach did not test positive for drugs. And that created a conversation about discovery and those kind of issues, and whether there was a report or not a report. So that's where I wanted to do this outside the presence of the jury. So where we were, we can begin again.
I think it would be appropriate. I think they've got an opportunity to communicate amongst themselves. Maybe they just know the answer at this point.
Okay.
Judge, I'm referring to the report that was given to Mr. Mayor by Mr. Thompson. The Friday, June 12th, Bureau of BCI forensic scientist David Davidson completed the analysis of submitted evidence. In addition, 2 digital photograph Davidson indicated the following question material submitted as item number 1 was found to be polymer that is 30-something minus 125 mils thick, having convex shape. The exterior surface of the polymer has a very fine texture.
I would appreciate it if you wouldn't read that quite so fast.
I'm sorry. The interior surface is smooth. Some of the edges of the polymer are jagged and appear to be torn, indicating that the piece was either a part of another item or has had material removed from it. Instrumental analysis and special library search revealed the composition of the polymer to be consistent with polyvinyl chloride PVC.
So that's what you were referring to?
Yes.
That's not only what he was referring to. He also asked Dr. Lehman, isn't it true that the bag was tested and tested not negative for presence of drugs?
Well, that, Judge, my question is
what I'm
maybe
getting.
inarticulately stated. In that report, it did not test positive for any type of drug.
Do you know if it was, in fact, was that analysis done on that date? Was that part of the analysis to see if it did have anything on it?
Of course not. That was a trace. That's a
I don't
trace
know.
guide. Specifically not a drug.
Hold on, I'm asking him.
I don't know.
Okay. Well, I think then,
Leonard does.
I
I've
think-
spoken to him about it.
okay. Well, I think that the question then would be not related. So the objection would be sustained to that question, and then you can follow up with the fact that well, I don't know if you follow up with this
Well, I
witness.
think
You
it does
just follow up with someone else that there was no definitive test done.
It's now the second time that this has been affirmatively stated by the state in this case. During opening statement, Mr. Thompson stood up and in talking about that bag, he indicated that it was tested and it did not have drug and it did not come back with the presence of drugs. Okay, so that's the second time this jury's had it. So I'm going to ask one time on the record, was that bag ever tested that came out of his stomach, that bag, was that tested in a BCI crime lab for the presence of drugs or any crime lab in the United States of America? Yes or no?
The test that was done, you have.
Judge, I want an answer on that.
Well,
It's yes or no.
my answer would be this. There was clearly nothing to test on that, or because it's a BCI technician, and if they would have seen anything on that to test, they would have tested it. So that's my answer.
No, that's
He's
not
a
clear.
trace
He's a
guy.
trace guy. We spoke to him when they gave this 2 days before the trial, only because we found out about it. We called him and he said we wouldn't do anything. We're not a drug lab. The drug lab's in a different part of the state. I'm a trace guy. I look at paint. I look at footprints. I don't do anything with drugs, period. That's a mischaracterization. And when I spoke to Special Agent Leonard, he said the exact same thing and specifically told me that he did not have it tested for the presence of drugs, period.
So
That's the
it
answer.
sounds to me like it was never tested by a drug. It would be someone like Tony Tambasco.
Right.
It would be looking. It was never tested for that.
It was not, Judge, but
Even though it
because,
sat in Tony Tambasco's office for 3 months.
because there's nothing to test. That's my point. There's nothing on there. You can't test nothing. I mean,
Then don't tell them that they
test
tested it and it was
Then
negative.
don't tell him that.
Yeah,
I didn't tell them
Grossly,
that.
yes, you
I'm
did.
asking
You
questions.
specifically said, isn't it true that that bag did not
He
test?
could answer
for-"
however he wanted to answer.
Well, I don't think you can.
And
ask
that
the
goes to the
question.
other point. I don't think this guy knows any of that.
Well, I get it. And I don't think it's appropriate to ask, that's not an appropriate question to ask if it was never tested. That do you know if for a fact it never tested positive for drugs? If it was never tested positive for drugs, you can't make that assertion in front of the jurors because you're giving them information that is misleading. And
Well,
you can't mislead the jury.
I
There was a
understand.
test done.
Not my intention, Judge, I apologize.
Right.
However,
Second time it's happened in this trial on that
as
issue.
Mr. Mayor, taking a shot, pointed it out, I didn't even bring it up. He brought it up, but the reason he brought it up is he's misleading the jury and wants them to think that it's a bag of methamphetamine and
It's a
it's legal.
reasonable
And
inference
that
that
is
this
not a
doctor has-
reasonable inference. As you've said, it's not been tested. So how is that a reasonable inference? It's
Circumstantial
absolutely a guess.
Well,
And he
it's not
said
a
it's a
guess. It's
guess.
circumstantial
He said it's a guess. He
I let
his
these
words.
guys go back and
Educated,
forth.
yeah.
Now, I want to say this, on the record. There is no evidence that that's a bag. None. It has not been established in any testing anywhere It was a fragment of a piece of plastic. And the evidence will be adduced that it's just as likely a piece of medical equipment that was used during the intubation than it was a plastic bag.
So there's
so the
actually
piece of
evidence
that they're
right
talking
here
about-
in this autopsy report that says it is a torn, parentheses, ruptured plastic bag-like object.
Then go
So
back to the comment.
There
if I may.
I want to follow up on this, and this is the other piece to this. This lab that they gave us, only because we found out about it 3 days before the trial, specifically excludes it as a medical device that was provided by Leonard for comparison. It's excluded they have 5 categorizations of competence in their finding, and it's 5 excluded, meaning it is impossible that the medical item that he brought to them met any of the same criteria. It is scientifically possible that what he brought after 6 months of looking for it that we never knew about as their smoking gun theory as to why this isn't a meth bag, their own scientist says it's excluded what they brought him. And so to say that it's just as likely is just a fairy tale. And I'm going to tell you one more thing. He's not even subpoenaed by the state of Ohio. We only subpoenaed him because we don't know what to do about this information that isn't provided to us in a case that we have been ran down for 9 months because we aren't ready for trial. How can you not be ready for trial when they're withholding evidence that they intend to stand in front of this jury and try and make a mockery of our argument? This is a trial by ambush. And the last thing about it is I think that the entire question about PVC material should be stricken. The jury should be made to disregard it because that is an expert report that was provided days before the trial by the state. They can't make any reference to it. They can't clump Davison. It's a non-starter in this case. If they wanted that in this case, they should have been in here begging for a continuance so that we would have the time to use it. We didn't ask for it because we didn't expect they're going to talk about it when it excludes it as their theory. I mean, what are we doing?
Judge, I'll say again, I did bring up the baggie, he did. I didn't touch it with.
How can I not bring up the baggie when it's in the
And it
coroner's
is not
findings?
excluded, he's misleading you. What I talked to Davison, and what he said was, it didn't match the object that Leonard brought to him. Not that it wasn't a medical device. It wasn't that medical device. He will say that.
How many others
And
did
he
you
said
bring to
to
him?
me over and over again,
Verify.
I have nothing to offer in this case. I have no idea what that was. I have no idea.
Are you intending to offer any testimony that you don't know what it is? Is that something that is being offered by a witness to say, are you offering a witness to get up here and say, I don't know if it's a plastic bag, I don't know what it is? I don't know what it is. Okay.
No, we do not plan to do that.
All right. So in that case, then I don't think we can argue facts not in evidence. So if it's, the problem with the state's argument is that the autopsy report says a plastic-like bag. So it's in evidence, it's in the autopsy report, so they can talk about it. Now you guys can talk about it that we don't know what it is, or it could be something else, but it's in the autopsy report. How does it not?
Then I would ask that the defense not refer to it as a baggie of methamphetamine. It's a plastic-like baggie.
Okay. Well,
And words are important, Judge. I mean, he's just said he doesn't know what it is. That's
really just not what he said.
And he also used the word when he talks about methamphetamine intoxication, and he admitted it, that I'm guessing. He said that, I'm guessing.
what an opinion is. Well,
it's not.
What he said was he believes it was meth because he believes that he had a amphetamine in his system, and he's like, well, the most likely amphetamine would be methamphetamine, and then based on all his other findings, that's why he came up with his opinion of excited delirium, because he relates it. So yeah, you're right, he says that he's guessing it was meth because of the presumptive positive for an amphetamine and being in the urine. I think he's allowed to opine those things, even though he's saying, I don't know exactly what kind of amphetamine class it was. I believe it's most likely to be methamphetamine, which is what I think his testimony was. So he's allowed to say that. We can't argue, we can't say something we know is not true, which is that the bag was tested, the bag-like item was tested, and it did not contain drugs. If it wasn't tested by somebody to confirm or deny whether there was drugs on it. So I would sustain that objection, and And so we can't ask that question because I think it's misleading. So.
And I'm going to ask for both of those questions regarding the PVC-like material, all that be stricken, because that's evidence that's not in this case. It's an expert report that was provided to us days before trial. They're not calling that witness.
Well, I remember the question about the baggie not testing for substance. And
The lead-in question, the lead-in question was, it's not a bag at all, it's PVC. Was the gist.
No, that's not.
Well, we could just read it back. Let's just read it back. I'm cool with
Read it
that.
back, that's not what I said. I said,
Yeah,
we
read it
don't
back.
know what
I
it
said the
is.
gist.
It's consistent with PVC. We don't know what it is.
That's what
I'm
I
not
said.
saying it's not a bag. I'm not saying it is. Nobody can.
You are absolutely saying it's not a baggie when you're asking questions like that. You know,
I'm not.
as much as I'm saying it's a baggie of meth, you're saying it's not a bag.
I'm not saying it's not a bag. We don't know.
Then don't argue
And
that
I
in closing.
think it's
I bet
unfair
you
to
will.
argue that.
I bet you will in closing, or your partner.
Well, I think that it's fair to say that it's baggy-like. So I think the state can argue that we don't know. We don't know exactly what it is. It's described as baggy-like. It's an exhibit, is it not? Is it going to be?
Yeah, and that's another thing. They took 4 or 5 pictures at the eye. They complained there was only 18 pictures. 1/3 of them, they're off the bag.
Outside of the body after it was washed. Outside of the body after it was
pictures
washed.
were taken until he told you that bag. Come on.
So if I
It's right here. It's right in the report I gave you. Yes, I do know. The picture wasn't taken where it was found.
in the body.
Well, I would-
no pictures were taken.
What I would
of the bag.
propose, hang on, what I would propose, I strike the last 2 questions and tell the jury to disregard those questions, and we get Dr. Lehman back. We continue on it in the future. We don't make arguments that it didn't contain drugs, because that's something that's not in evidence, and it's not going to be put into evidence. You can argue we don't know what it's baggy-like. We don't know what it is baggy-like. You can make that legitimate argument.
But you said we can't say it didn't contain drugs, then I'd ask that you tell the defense that not to argue that it did contain drugs.
It's an inference.
What's good for the goose?
It's not good for the goose. What you can do is
why are they allowed to infer it did, and we're not allowed to infer it didn't?
Well,
I would also ask, Your Honor, here is the exact language that comes from the medical report.
okay.
The gastric mucosa is arranged in the usual rugal folds. The lumen contains 10 milliliters of tan fluid in a single piece of semi-lucent cellophane-like material, approximately 1.0 by 0.75 inch. That's the totality of the description of that plastic. What they're referring to, can I finish a sentence anytime today?
When you say us, it's asking for a response.
So
I'm saying that the reference to the bag-like material is in the summary in item 1.
Right.
Torn, ruptured in parentheses, plastic bag-like object in the summary. That's a summary. That's not how it was described in the medical examiner's report.
And that's fair. You can absolutely point that out. That's absolutely fair to point out to Dr. Lehman. That
Totally cool with that.
I just don't want to, and I get you're saying we don't know what was in the bag.
If anything.
They're going to say, though, they're going to argue.
It was a bag.
They're going to argue an inference. We know this. Mom's already testified that he had meth abuse issues. I don't know if there's going to be testimony about whether he was, what happened in scans coming in. You told me a little bit about that in pre-trials, that there might be, when they ran into a scanner, there might show something. I don't know. I'm waiting to hear that. But I think there's enough that there's an inference, and then with what this doctor says, his opinion about excited delirium, I think there's enough that it can make an argument that there's an inference that the bag contained. And you can follow that up and say, first of all, we don't know it was a bag, because we're not sure, bag-like. And second of all, we don't know what was in it.
We agree. Yeah. We're not saying they can't argue against it.
Right.
We're just saying they can't get up there
You
and
don't
start
want to
saying
say-
there was a test done and there were no drugs in it.
That's
apples and
what I'm saying.
oranges.
I'm saying don't say that there was a test done, because there was no affirmative test done on the bag to determine whether it contained drugs. So don't make that argument. But I think everything else is open to argument. So I'm not limiting anybody. I just don't want to say something that we know isn't true. That is, the baggie was tested for drugs and it didn't have it in there. And I guess you could make an argument, we don't know if it's a bag, we don't know what it is. So if you say it's PVC, we don't know what it is, right? We don't know what it is, it's plastic.
We're going to object to any testimony that is PVC.
Because we don't know.
No, when there is a report
we know
that we
there's a
were provided
report.
with 2 days before trial.
I keep
which is
hearing that, Your
excellent.
Honor. We got it when he got it.
That's not
That's
true.
just absolutely.
That's not true. That report says Forrest Thompson asked us to look at this to determine what this bag is.
That's absolutely correct.
Okay, and on top of that, we know that Dr. Mitchell received those items, including that report.
No, Dr. Mitchell did not receive that report.
It's in his materials
He
review.
he responds, he makes reference to notes from the BCI agent. That's what he's referring to.
And
He never refers to this, not that I'm aware of.
That's, first of all, that's the autopsy report. But second of all,
Shoot, wherever I live.
he absolutely references the BCI report regarding polyvinyl chloride.
Well, now you're just arguing that you got it.
100%.
That you got it, because you got the expert report 9 months ago.
No.
So you got it.
No, we
So
didn't.
you did get it. You're saying
We
you
got Mitchell's report.
Right.
With no explanation
Right.
as to what it is.
Well,
And
you
so
bothered to follow up.
we did. We called that guy and we called Davidson.
Same old defense.
Well, again,
Same old defense attorneys.
Same
wait a
old
minute,
defense
no.
tricks is what I said.
Well,
Well, I didn't get it. I didn't.
so you're arguing.
How else do I get it unless you give it to me?
You're
You
arguing.
did. You had it in Mitchell's report. You just said you did. You just admitted it.
Pull Mitchell's
you
report
just
out.
admitted it.
Pull Mitchell's report out and read what it says, and you tell me.
I'm not doing what you said, Jim.
Well, you're telling me
I'm
how
not
it is.
telling you. I'm telling you you got it, and you just admitted it on the record.
We didn't
You
have
just
it.
admitted it.
We didn't have it until that guy showed
You
up.
just admitted it. You
Before
stepped on
trial
yourself.
started and
Hold on.
handed it over.
Let's put Leonard under oath and ask how this all went down.
Well, I assume he'll probably get your oath at some point. You probably.
But it's going to be as to inadmissible evidence. I think it's important enough as a discovery violation that we have testimony under oath, because that man right there is going to say that he walked into this courtroom on the morning of the final pretrial, which was days before, and handed an envelope with my name on it to this man, Mr. Thompson, and explained to him what it was, which were the contents of all of the reports that we never got and all of the narratives that this man created that all had to do with the PVC bag testing that went on at BCI. 2 separate lab reports and a narrative that we never had. And the only reason we became aware of it is a cryptic line in the Mitchell report that references a report that was done by some scientist Davison that we put together to mean, well, maybe BCI did some more stuff with this. Probably not, because every pretrial we showed up to, we said we want all the BCI stuff and all the lab reports, and we're sure that we had it all. And I guarantee you, if Agent Leonard gets up on that witness stand, which will take about a minute, he's going to say that's exactly how that went. And the way the whole process got triggered is because I called him, and he called me back a day before the pretrial or 2 days before the pretrial, and just was honest with me about all the extra stuff that was done and had no explanation as to how we wouldn't have it, because he gave it all to the prosecutors in the matrix when it happened in real time, which was 2 years before this case ever got indicted. And they used that material and sent it to Dr. Mitchell, and it formed the basis, apparently, for some of the opinions that he gave. And so that's how this went. And for him to say, oh, you stepped on yourself and you actually had it all the time, come on. That's how it happened. Leonard knows it, and Davidson knows it, because they were both just honest in talking about how it happened.
So your argument, get back to your argument, you don't want them to say anything about PVC because
Absolutely
that was
not.
something that was done in a report you didn't get until not within the 21 days.
Correct. And when we sat in your office in the continuation of the final pretrial, Mr. Thompson indicated, well, we're not using that anyways. There's no need. And as soon as we talk about this bag, they can't wait to get up and start talking about it.
All right, well then, the ruling is don't talk about baggie being tested for drugs if it wasn't, and don't talk about PVC tests if those weren't provided in discovery before 21 days before trial. And then that's just simple. I don't think we need to put anybody on it, do any testimony, just don't.
That's fine, Judge.
Don't bring
I
it
don't
up.
see Agent Leonard sitting over there disagreeing with any of this, so I think we know what's up.
All right, well, that's the ruling. Let's get our lunch break, and then we'll come back, and I'll strike those 2 questions, and we'll continue on.
Judge, what time are we supposed to be back?
Hey, was that fun? Because I thought that was kind of fun. It was like a bunch of schoolgirls fighting over a boy, except it was a plastic bag and middle-aged men. Yeah, that wasn't a good example. Anyways, I hope you all enjoyed that. I thought it was pretty interesting.
No idea.
You think he had a plastic bag? Was it drugs? let me know.
So when we took a break, I had some conversations with the attorneys on the record, but outside of your presence, ladies and gentlemen. What I'm going to do is strike the last 2 questions that Prosecutor Salisbury asked. Just strike them, to disregard those last 2 questions as though we never heard him. He's going to continue his examination of Dr. Lehman at this time. You may proceed.
Thank you. So, Doctor, in their cross-examination by Mr. Mayor, talked about petechiae, right?
Yes.
Is that, and you've already said the one thing I was going to ask you about, that it could have cleared up in the 7 days while he was in the hospital, correct?
Yes.
If it was ever present.
Yes.
But also, just to be clear, petechiae is not always present in an asphyxiation death, correct?
That is correct.
Okay, so you've seen even strangulations where there's no petechiae, correct?
Yes.
Okay. That's just kind of one indicator that you look for, right?
That is correct.
Okay. Why? So, again, back to this confirmatory test versus the screening test, as you called it, or the initial test.
Yep.
How do they confirm it? Do they confirm it? They would confirm it with blood, if I'm not mistaken, correct?
If it was at the coroner's office, we would do it with blood. But
In an emergency room, I mean.
in
the
emergency
hospital.
room, I don't think they would normally do that. It's an expensive test, and it would probably take a week to get the results. So I'm pretty sure that they would not routinely do it anyways.
Not routinely, but if they were asked by law enforcement, say, to do it, how would they do it?
It would probably be a gas chromatograph mass spectrometer. It would be very specific to one chemical, or in
Right.
the case drug, as opposed to a class of drugs.
Right. And that, again, would that be blood or urine?
I have trouble hearing.
Would that be blood or urine?
They would probably do it on the urine, because that's
Okay.
what they're working with.
Okay. And as far as injury goes, the same, the lack of broken ribs or the lack of bruising, that's, you've seen cases of like this where that isn't present. I mean, that's not that unusual, is it?
No, not it's entirely possible that it would not be present.
Okay, all right. And again, that wouldn't, the fact that that's not present wouldn't rule out that finding of death by asphyxiation or positional asphyxiation.
That is correct.
Okay, all right. That's all I have, Doug. Thank you.
Thank you, Assistant Prosecutor Salisbury, Attorney Mayor. Follow-up?
Just a couple. On that last question, the lack of petechiae doesn't rule out an asphyxial type of death, correct?
Correct.
It does nothing to help that finding, though, either, does it?
That's correct.
And with respect to lack of compression-related injuries on the back, based on the chest compression,
Yes.
the lack of bruising on the back, although not required to make that finding, correct?
Correct.
It does nothing to help support it either, correct?
That is correct.
And that goes for any evidence of trauma internally, like fractures or broken bones.
That is correct.
Have one more?
Yes.
Dr. Lehman, thanks for coming back after lunch, but I think that's all we have.
Okay, thank
All
you.
right.
Before you leave, Before you leave, Dr. Lehman, I want to make sure to see if any of the jurors would have a question. If you have one, if you have a question, put it on a separate sheet of notebook paper, question or two, and provide it to the bailiff. Parties can approach.
Sir,
Good morning.
could you state, afternoon. Could you state your name, spell your last name for the record, please?
John Rodriguez, RODRIGUEZ,
Where are you employed, sir?
Ohio BCI.
And what is your job with Ohio BCI?
I'm a special agent with the Ohio BCI.
And are you a sworn peace officer in the state of Ohio?
Yes, I am.
And how long have you been a peace officer?
12 years with the state of Ohio, roughly 10 years down in Florida.
Okay. And as a as an agent, a special agent for BCI, just tell us generally what your duties are.
Currently, I'm a member of the Special Victims Unit with PCI. We handle sexual-based offenses.
Okay.
And I'm also a special agent. I handle a variety of offenses as requested.
And if you remember back to September of 2019, how were you employed the same way? Did you have the same job?
Yes.
Okay. Did you receive an assignment to attend the autopsy of Alexander Rios?
Yes, I did.
And can you tell me about that, how you got that assignment?
It was the morning of September 30th. I received a call from Special Agent Supervisor Mark Kohler of SIU, Special Investigation Unit down in Richland, Ohio. He mentioned to me that they had got a call in the morning of that Alexander Rios was going to be autopsied that morning. And would I be able to attend the autopsy? Of course, I accepted the assignment and went down to Montgomery County.
Okay. And when you got to Montgomery County, just tell us what happened.
I entered the lobby, presented my credentials, signed the ledger they had at the receptionist, and stated I was there for that purpose.
Okay. And what happened?
I was told to wait a second. Montgomery County investigator from the coroner's office, from the Richland County coroner's office was in there, and he was notified. I believe it was Robert Ball. Several minutes later, Robert came out, asked me why I was there. And I told him that I was called by my supervisor to attend the autopsy.
Okay, and what happened then?
Robert said, wait a minute. I believe he went back to the room. I immediately called Mark Kohler, told him about the circumstances about.
What do you mean? Why did you do that?
Well, obviously because there was some question on why I was there.
Okay.
So I believe just because of the questions I was being asked, they didn't know I was coming.
Okay.
So I called I called Special Agent Kohler. He says, advised them that we were there. We were advised of the autopsy, and I responded.
Okay.
I was eventually let back near the examination room. I was provided some PPE, personal protective gear. I signed another ledger, went into the autopsy room.
Okay. When you entered the autopsy room, what was happening?
The examination is based on my experience with prior autopsies. The examination was well underway.
Okay. Why do you say that?
Just the condition of the person being examined.
Okay. And were you notified of anything else that had taken place before you got into the room?
Mr. Ball Detective Radio Check had told me that there were photographs that were already had been taken.
That were already taken before
Yes.
you got in the room? Okay.
Yes.
And then, so how long total were you in the autopsy?
I got to guess maybe less than a half hour.
Okay. And did you take into your custody any evidence that was obtained during that autopsy?
Yeah. Yes.
Tell me about that.
During the examination, it was mentioned by the person examining Mr. Rios' body that a piece of plastic was found in his gastric. That was the exact words mentioned by the attending. The piece of plastic was removed from his body and placed on a table. A short while later, the examination concluded, and I had left the examination room. After it was obvious that it had concluded, I already had left. But backing up a little bit before that, me and Robert had mentioned that if BCI had requested any information, any documents or anything, that we would have to request those items, including the photos.
Okay.
So the plastic item that was extracted from his body was, I didn't have any intention of taking this custody, but when I exited the exam room, a person from the staff of the Montgomery County Prosecutor's Office approached me.
From which office? I'm sorry.
From the Montgomery County Coroner's Office.
Coroner's office.
Yes.
Yeah, you said prosecutor's
I'm
office.
sorry.
All right.
I apologize.
That's right.
Anyway, I was in the process of signing out. So they came out. The item was already bagged. and I had signed a property receipt to take custody of the item.
All right. I've already shown this. You okay with it? Yeah, we open it. So Agent Rodriguez handing you what's marked for identification purposes. It states exhibit number 6.
Okay.
And you watched us over at the table pull the contents of that out, correct?
That's correct.
Okay. Can you tell me what that is, please?
That's the item that I took custody of in Montgomery County Coroner's Office.
And how do you know that that's the same item? What markings are on that exhibit that cause you to believe that's the same item you recovered and took into evidence?
It was handed directly to me,
Okay.
and I'm familiar with the item.
Okay. And is there a chain of custody? Well, let me ask you this. What did you do with it? When you
I took it into custody, and when I left the coroner's office, I contacted Agent Lerner, Eric, and stated what I had taken to custody, and can we meet so we can exchange?
Okay. And did you do that?
Yes,
So on that day, you handed it over to Agent Leonard?
that's correct.
Okay. And so the first line on the chain of custody is from the Montgomery County Coroner, is that correct?
That's correct.
And then that's your signature?
Yes,
And then over to Agent Leonard, right?
right.
Okay. Thank you, Agent. That's all I have, Judge.
Thank you. Cross-examination. Attorney Boone.
Thank you, Judge. Good afternoon.
Good afternoon.
My name's Sean Boone. I represent Mr. Cooper here.
Okay.
I'm gonna ask you some questions.
Sure.
If you don't understand what I'm asking, let me know. I'll try to do a better job, okay?
Sure.
All right, so you testified you're a special agent with BCI, correct?
That's correct.
Can you tell me what BCI is?
Bureau of Criminal Investigation.
And more specifically, works for what agency? Under what agency, I guess?
Actually, we work under the Attorney General's office.
Okay. And it's my understanding that BCI is like the investigative agency of the Attorney General's office.
We are the
correct?
investigative agency. Okay.
And you are essentially called into cases either to assist local law enforcement, correct?
Yes.
Or to just completely take over a case, right?
Yeah. I guess that's.
Do I have it wrong? Maybe I have it wrong, so you can just tell me.
We're a requested agency. We don't have original jurisdiction, so we have to maintain a request. There's a couple different ways we work on cases.
Okay.
But we're assisting the agency.
Okay, ultimately assisting the agency. And you have been a special agent with BCI for how long?
I started back in 2012.
11 years now?
11 years ago.
Gotcha. And you're currently in the Special Victims Unit?
That's correct.
That's sex offenses, right?
That's correct.
Not this case, right? Were you in that unit back then?
Yes.
Okay. So explain to me how somebody from the sex offense unit of BCI ended up going to an autopsy on this case.
We're a rather small agency, and I work a variety of offenses. And I assist on a number of offenses. I've been called out on officer-involved shootings, assisted on homicides. So it just depends. I was the closest agency. I was the closest agent to that request, so I accepted the assignment.
That was my assumption.
Okay.
This autopsy happened in Montgomery County, correct?
That is correct.
That's like in the Dayton area, is that right?
That's correct.
And where is your office?
I'm in London, Ohio.
You are in London, Ohio, and that is just west of Columbus. Is that
Yes.
accurate?
Roughly about 35 minutes.
35 minutes west of Columbus. Now, you testified that you spoke with Agent Linhart here.
That's correct.
He has an office up in Richfield, is that
That's
right?
correct.
And that's up near Cleveland.
That's correct.
So it would have taken him a while to get from Cleveland down to Montgomery County, right?
I assume.
How long did it take you to get to Montgomery County?
I was residing in the Hilliard County, the Hilliard, Franklin County area.
Okay.
I wasn't in the office that day, so when I received the call, I was still working local at my home.
Okay.
So roughly an hour and 15 minutes.
All right. And this autopsy, we've heard testimony, and I think you testified to it. It happened on September 30th of 2019.
It did happen on September 30th.
And that was Monday morning, I think.
I believe so. I don't have a calendar in front of me, but I'll stipulate that.
And according to the autopsy report, the autopsy began at 9:08 a.m. Were you
Okay.
aware of that?
Mm-hmm.
Does that sound about right with your timing?
Again, I didn't arrive when the autopsy started. I arrived when I arrived.
Sure. Do you recall when it was that day, exactly what time maybe, that you got the call to head on down there to Montgomery County?
I didn't keep a log of the time.
Okay. But it was morning time, right?
That's correct.
And you were working from home.
Mm-hmm.
Are you aware that BCI became involved in this case on September the 29th?
No, I did not.
Okay. Your first knowledge of anything that was going on was when you received a call to head on down to Montgomery County and
That's correct.
witness this autopsy. And that's something that you do,
Yes.
correct?
Mm-hmm.
This is not the first autopsy you've gone to.
No, I haven't.
Okay. So you get down there and it's some point in the middle of the autopsy, is that right?
I don't know how far along it was. I mean, when I went into the room, it was obviously Mr. Rios had been worked on.
Okay. And explain that to me. What do you mean by had
Just
been
the condition of his body, my prior knowledge of,
He had already been opened up.
That's correct.
Essentially. Okay. And you mentioned that you had, when you got there, you had some conversations with Bob Ball, is that right?
Mm-hmm.
And I think you testified that he works with the Richland County Coroner's Office.
That's to my understanding, yes.
Okay. And is it commonplace, if you know, to inform a coroner's office, hey, we're going to be heading down here to take a look at this?
I mean, it happens in a variety of ways. We were involved. That's why I got the call.
Sure.
I don't know where the investigation was at that day. I know I got instructed to go down to the coroner's office to assist in any way I could.
And you said that Mr. Ball, did you make a phone call to your supervisor or did Mr. Ball make a phone call?
I made the call.
Okay. And did Mr. Ball ultimately end up speaking with Mr.
I
Kohler?
don't recall that, no.
Okay.
He didn't do it on my phone.
Gotcha. But after you spoke with Mr. Kohler, Mr. Ball said, come on in, right?
I don't think it quite happened that way. I think he went back and then returned.
Okay. But then brought you in?
Yes.
It didn't prevent you from coming in or anything like that?
No, he escorted me back eventually.
Sure. And you were allowed to go essentially wherever you wanted in the autopsy room, right?
No.
Tell me.
When I went back to the autopsy room, my specific purpose was to go back there and view the autopsy.
Sure. And we've heard some testimony from the actual coroners that they said that the people observing can freely look at what's going on and things like that, right?
Okay.
And you were allowed to do that, right?
Sure.
They didn't make you just sit in the corner and
No.
and you could see whatever you wanted, correct?
That's correct.
Okay. And during this time, people were talking, coroners were talking, things like that. Yes?
That's correct.
Okay. You mentioned it was about a half hour that you were there, less than a half hour.
I didn't keep track of the time. I apologize.
That's fine.
I know it was a brief period that I was there.
Okay. And ultimately, when you were there, did you hear anybody talk about the piece of evidence that they had collected from the gastric contents? Were you aware that that had happened
Yes.
while you were there?
Mm-hmm.
But ultimately, you started to leave without actually collecting that evidence,
That's
right?
correct. I did not collect the evidence.
Okay.
As I was in the room.
When you were called by BCI, were you told, hey, collect any evidence that they might have?
No.
Okay. But ultimately, somebody from the Montgomery County Coroner's Office came out and said, hey, you might want to take this with you. Yes?
Yeah, more or less. That's the way it happened.
Sure. And you did, right?
That's correct.
And I think it's your testimony that you took it with you and then you met up with Agent Laner later that same day, is that right?
That's correct.
Okay. And do you remember where it was that you all met up and passed that off?
We eventually made a location that was nearest to kind of in the middle for both of us. We ultimately met near 71 in Delaware.
That 36, 37 exit.
Yeah, that's
right?
correct.
Yeah. And you handed it off to Agent Lainert, right?
Mm-hmm.
And that essentially ended your involvement in this case.
That did end my involvement.
Until right now,
That's
correct? Okay. If I could have just 1 minute. Sure.
All right.
Hold the door!
All right. I'm not going to call anybody unless you come down from down here. Okay, this is the last time I'm going to ask you. I've asked you for like 5 minutes. I'm not going to do it anymore.
What do you mean?
Okay.
I'm not supposed to be in here.
We're going to put you in a restraint chair for your safety due to not listening and being on the divider, causing a risk to harm yourself. We don't have time to continue that all night.
There's no reason
Okay?
for it.
All right, this is the last time I'm asking, then we're going to go in. We're going to go ahead and put you in a chair.
Why can't you just open the door?
Right here, go. All right. Come on down.
Do that, CO,
No.
Handcuff.
Is that a yes or no?
I'm supposed to
Go ahead and turn around, put your hands behind your back, and cuff up for me. If not, we're going to come get you.
All
right.
You guys
No.
are wrong, man.
Okay, we're coming in to get you.
Ready?
Let's go.
Go.
Cuff your back. Hands behind his back here.
Come on, man. I'm not even fighting.
Use your taser.
I'm not fighting.
Tasing.
Tasing.
Fighting.
Take it off.
Taser.
Taser, taser, taser.
I'm not even fighting.
Glasses, let me get my goddamn glasses. Taser.
Ow! Ow! All right. Ow! Oh! Can someone
Try tasing.
Can you explain to me? Because you're a dumb.
No, you're the dumb.
I didn't say you were.
Got out of the cell. Really? Yeah, he's looking.
Oh!
Okay, you can see Officer Cooper there with his right foot on the back of Rios. It'll be here in the next 30, 40 seconds, 50 seconds that he then shifts all of his weight to stand on the back of Rios for 7 seconds.
You need to. We have anybody else available?
I got this, man. You got
Rios? Rios. Alexander Rios.
Oh, that's the one that they sold the warrant on last night, wasn't it?
Yeah, he thinks he's supposed to be out of here and he wouldn't get down off the wall.
Take me.
Cut it off. Cut it off.
Turn it off.
I would like to help.
Let go of the cuff. Ow. Let go of the cuff.
For the rest of this video, and again, this is a warning, this is pretty graphic, Rios is unresponsive and you'll start to see him turn blue.
I try to pull that thing out when it comes out.
Get a pair of shackles.
And we got another handcuff.
Where's the other hand there?
I got it.
Where's that?
Behind me now.
I only have one hand, guys. I can't hold it.
Do you want a pair of shackles?
Okay.
Well,
Somebody
I
get
can't
beside me. Nino, you're
Buck.
gonna have to get up. All right.
Grab some. Oh, he's got them.
Cooper, you ready?
We got shackles.
Ready?
All right.
Down.
Shackles.
Give me the other hand.
And there is now Officer Cooper putting his knee into the back
Shackling down there.
after standing on Rios. And at no point during this next 30, 40 seconds does anybody realize he is unresponsive.
Where's the radio sign?
Think that's gonna be too big? Let's fly this foot out there?
What we got?
Try it.
I might be able to cinch up around his ankle.
Do his ankles now, so.
Keep going.
Okay, Gardner? Yeah. Let's come on the other side of Long. When we come up, we're going straight up into the chair. All right. Cooper, I'm behind you. And Long, I'm behind you guys.
I got you.
Yes, all right, I got the chair so it doesn't move. Okay. You two ready?
Rolling. He's turning.
Straight up.
Hear me?
Get up.
He's turning blue.
Get up.
Call
Call the squad. Master Control, call the squad.
We need turn him on his side. Turn him on his side. Just laying down on the side. Lay him on the side. Try to get us some oxygen, make sure everything's going okay for him. What's his last name again?
Sir, would you state your name, please, and spell your last for the record?
Jamal Odell. Said spell last O''D''E''L''.
And sir, my understanding is that you're retired from the Richland County Sheriff.
One thing I wanted to add before this part starts is, wow, that video is intense. And number two, this is one of the former correction officers that was involved in that altercation. When he came in, the judge sat him down and he read him his rights, Miranda warning, and told him he had the option to not testify. He was able to plead the fifth, and he chose to testify. Well, he said something about, I guess. So they are continuing on with letting him testify. Later, after his testimony, they bring in another officer, do the same thing, and he's still employed, so he has an attorney through the union association, whatever it is, and his attorney advises him not to testify, and there's multiple other officers still employed that are advised not to testify. So there's quite a few of them aren't going to, but he is one of the ones that actually are, who was involved in it. And Debbie, the charges are reckless homicide and something manslaughter. I'm sorry, I don't have it right in front of me.
Sheriff's Office?
Yes.
Is that right? And when did you retire?
2020 in September, I believe. August or September.
And what were your duties when you did work there?
I was lieutenant on third shift.
Okay. And lieutenant from corrections officer?
Corrections.
You're, just to be clear, you're not a duly sworn peace officer, are you?
No.
Okay. How long did you work as a CO?
Just over 20 years.
Okay. All with Richland?
Yes.
Okay. And I mean, you know why we're here on September of 2019. Were you present for an incident that happened between the COs and Alexander Rios?
I was present.
And tell us what your role was.
My role was initially observing the behavior of this individual and making a determination of what we needed to do to proceed to take care of what we had going on.
Okay.
So basically, as a supervisor, I was seeing a situation that needed to be taken care of and responding to it.
And tell us about that. What was the situation you thought that needed to be taken care of?
We saw an inmate in his cell, and he was acting in a manner that caused a risk of harm to himself or possibly others.
And what cell specifically was that? That's not a normal cell, is it?
It was in our booking area, and cell 12. I think it was cell 12.
Okay, but I mean, he was put there. He wasn't. That's not general population, correct?
No, booking is it was on suicide watch at that time.
Okay.
In booking.
And he had the suicide gown on, correct?
Right.
All right. Who made that determination?
It would have been medical staff along with whoever the officers were at the time that made that decision based on his behavior.
Okay, and it was not you?
It was not me.
Okay. And you said you saw some behavior that you thought needed to be taken care of. Tell me specifically what was going on that concerned you.
He was up on the divider inside of the cell, and he was reaching towards the top. We have a sprinkler head there, and it appeared that he could easily fall down, he could harm himself. His behavior was such that it didn't look like he was, it seemed like something was going on that was of significant concern to us from a medical standpoint.
Who was before the video started, which I believe you originally had the video camera, correct?
Yes.
Before that started, what was happening? Were you talking to him?
When I first observed, when I came into the area, I observed him up on the top there, and I knew right away we were dealing with someone that was definitely a potential risk of harm to themselves or other.
Okay. And so what kinds of things, before the video started, what kinds of things was he saying and doing to you? What was your interaction?
It sounded to me that he believed that he wasn't supposed to be there. It wasn't right that he was inside of there. So I tried to speak with him, but in order to do that, try to get him to come back down.
Okay. And that's not that unusual, is it? That somebody in a seg cell, would you call it, segregation cell, right? That they don't think they should be there?
That's not unusual, but the fact that he's on top of the divider and risking a potential harm and not sounding like he understands the questions very well, and what he's repeating, that sounds like a concern.
Okay. Well, and tell me about that. What do you mean you didn't understand the question? What kind of questions were you asking that he didn't understand?
I can't recall 100%, but basically it was around his health and well-being, making sure that we could get him to come down and find out a little bit more about what was happening with him personally.
Okay. When he was saying, and so after the video starts, we've heard a little bit about it, he's saying, I'm not supposed to be here, man, right? That couldn't you have taken it that way, like, hey, I'm not trying to harm myself. Why am I in this suicide smock? Why am I in this cell? Isn't that a reasonable interpretation of him saying those things?
Yes.
Okay. Did you interpret it that way?
No.
You did not. How did you interpret it?
I interpreted that it wasn't something. It was his situation wasn't a situation that seemed understandable. It seemed like he had a little bit of confusion personally.
Okay. All right. And so, what was decided to do?
So, can you repeat again?
What was decided? What did you decide to do?
So, for his safety, we decided we'd take him out of this cell and have him placed in a restraint chair.
Okay. And what was the plan? How did you go about accomplishing that?
We had the restraint chair there. We had officers, we called for officer assistance. And the plan was for him to turn around and to cuff up through our food flap. Mm-hmm. And we realized that if he doesn't listen to our commands, then we have to open the door and we have to get him for his safety and put him in the restraint chair.
Okay. And so you knew there was a potential for use of force?
At the time, when we went in, yes.
Okay. And in fact, isn't that why you started the video?
That and to show that we're attempting to have conversation, that we're giving them opportunities to comply, that we're having a conversation, yes.
Mm-hmm. But isn't it, it's my understanding, and correct me if I'm wrong, that at the time anyways, that it was the policy of any time that there was a planned use of force that you'd videotape that?
Yes.
Okay. And so you did, right?
Yes.
You started videoing it, right, correct?
Yes.
And then were you the one that made the ultimate decision to open the door?
Yes.
Okay. And so what's the plan before the door opened? What was the plan? What was the plan supposed to be? There was how many officers were there?
I don't recall.
Okay. But more than a couple. Okay. What was the plan? How were you going to extract him? Let's say he didn't do what he did and he just remained up on the wall or just remained in a cell? What was the plan?
Well, if he's up on the wall, then officers would go in and they would help him come down from the wall and to the divider and then put him into the restraint chair. And then other assisting officers would help to make sure the restraints were put on there.
Okay. And then what's the plan if somebody does what he did, which is run?
When he runs, then it's a situation that we have to respond to where he's at. If he's not compliant when he's open in the area, then we have to assist him down, to the ground and try to get him handcuffed, try to get him secured so we can put him in a restraint chair at that point.
Okay. And so this is all for his safety, right?
Right.
So, and we've seen you've seen the video, correct?
Mm-hmm.
He wasn't going anywhere. In other words, that's a lot. And we visited yesterday. All of us did, the jury included. There's nowhere to go, right? He's locked in there. He's locked in that booking area. He couldn't have escaped that booking area, could he?
Not by opening the door unless someone else did at some point.
Right. So, and not by opening the door, you said, but not by any way. I mean, he couldn't get out of there, right? So, and there were no other, as we saw the video, there were no other inmates that were out of their cell, right?
No.
So no other inmates were in any kind of danger, were they?
No.
Okay. So this was just solely for him.
He's also, though, in that situation, he's a threat to himself, and he's also a threat to officer safety as well. So it's a concern for everyone at that point.
And so what was immediately done was what? I mean, he runs, and we saw it, and we're going to see it again. He ran around a corner there, and what happened?
I believe an officer met him and tried to assist him by getting him down, and other assisting officers helped that officer to do the same.
Were you present when he was eventually taken down?
Yes.
Okay. Isn't it true that he was taken down by one officer?
I don't recall.
Okay. Do you recall that one officer tried to take him down and he slipped out of his grasp, and then a second officer took him down by himself? Do you recall that?
I honestly, I don't recall.
Okay. So, again, this is for his safety and officer safety. I understand that. Why the need to take him to the ground? Why couldn't you just? You had four or five officers there, right? Why couldn't you just grab his arms and like we see on TV, right? Put him behind his back and cuff him and put him in the chair.
Well, one, he was not complying, and second, he presented something that we thought was highly unusual with his behavior. So when we noticed something going on with his behavior, we realized that that's a general process for us to assist him down, and then to have assisting officers handcuff and to shackle.
Okay. All right. So at what point did you relinquish the video and give it to, I think you gave it to Officer Mahan or something?
When it became apparent that we were dealing with someone that was presented more than the usual set of circumstances of concern from a safety standpoint.
All right. And so what did you do?
What did I do? I assisted his legs. His legs?
Okay. Tell me about that. Both of his legs, one of his legs, how did it? Both?
Both.
Okay. And at that time, with the time you got involved in that, how many officers other officers were involved?
I don't recall. I know there were a few, but I don't recall the actual number.
Okay. Well, would you disagree with me? Was Officer Long was there?
No.
He was not?
I would not disagree with you.
Oh, I'm sorry. Well, let me ask it a different way. I'm sorry. It's a bad question. Was Officer Long there?
Yes.
Was Officer Long Shore there?
Yes.
Was Officer Pendergrass there?
Yes.
Okay. Was Officer Cooper eventually there?
Yes.
Okay. And for the record, do you see Officer or former Officer Cooper in the courtroom?
Yes.
Can you point him out for me, please? Tell me what he's wearing.
He's wearing a gray outfit and a black tie.
Just point to him so I know who you're talking about. Thank you. Just so I know you've expressed to Mr. Thompson several times. You and Officer Cooper or former Officer Cooper are personal friends. Is that correct? You're
Yes.
You're close with this family.
Yes.
Okay. And there was another officer there that has since left. It was. Do I have the Prandy? Is that a name? Do I have that name wrong? Sorry. Gardner, that's one thing. No, I'm sorry. Gardner was there too, correct?
Yes.
Okay. Thank you. So that's, and including Officer Mann, or Mahan, however you say it, that's 6 officers, correct?
Okay, yes.
I mean, I'm not asking you to agree, right? You can count them. And so what were the other ones doing, to your knowledge?
Well, we had the one that was recording once it was handed off. We had a few that were up front trying to secure his arms, and I was trying to secure the legs, and there was, I do believe, another officer behind me.
Okay, doing what?
If there was any movement, perhaps he was going to be utilized to use a taser.
Okay. Was a taser deployed?
Yes.
By whom?
Well, there may have been a number of deployments, but I know that one of the officers, Longshore, did deploy a taser, and then later on in that incident, I also did.
Okay. And the first deployment of a taser, is that the one that went into C.O. Cooper's hand?
I believe so, yes.
One of the prongs?
Yes.
The other prong went where?
I don't recall.
Do you know that if it went into the suicide suit?
I don't recall.
Okay. Let's say it had gone into the suicide suit, would that have made any contact or have any effect on Alexander Rios? It's a thick suit, right?
Yes, it's a thick suit.
And likely that if it went into that suit and got stuck, if we hear testimony of that later, then that would have had no effect on him. Does that seem reasonable to you or not?
It seems reasonable, yes.
Okay. All right. During this time, were you able to get Alexander Rios in the prone position on his stomach?
Were we able to, and from the beginning of our incident with him to the end, we were not able to gain compliance in that way until likely towards the end, the very end.
Toward the end?
At the very end, once we recognized that he was in a state that we had to do something along those lines, yes.
Okay. During that time, did you notice Officer Cooper's foot on the back of Alexander Rios?
I do not recall.
Okay, not during the incident. Because you were busy doing what you're doing, right?
Right.
All right. Now, you have been trained in use of force, correct?
Right.
And that's part of your training is because you were CO in situations like this, correct?
Yes.
Okay. Have you ever been taught or trained that standing on someone's back or putting pressure on someone's back with your foot and with body weight is an acceptable form of restraint?
No.
Okay. And as a matter of fact, you're trained that that is not an acceptable way. Isn't that true?
Yes.
And why is that? Do you know? Do they tell you why not? They say don't do this, right? But here's why. Do they tell you why?
Well, we know when it comes to safety, we can try to do what is necessary in order to be safe, but we have other methods that we use that would be more successful under those circumstances.
Well, okay, fair enough. But I'm asking you, Why did they tell you not to do it? Did they tell you why, don't do this, because fill in the blank?
We are aware that some harm can come
Okay.
to an individual.
Okay.
Yes.
And you're trained that way?
Yes.
Right. And so you've watched the video before, so you gave a statement to Detective Radio at about 3:44 a.m. Does that sound right to you? I know you probably don't remember the time, but...
Yes, that sounds reasonable.
Okay. And that's actually quite a while after the incident happened, isn't it?
Yes, probably a few hours.
A few hours, right? Three and a half hours
Yes.
later, right? Do you remember what transpired between the time that this happened and Mr. Rios was taken to the hospital and before Detective Radio gets there and interviews you? What were you doing?
What was I doing?
Yeah.
Initially doing all the review of video, contacting our administration, letting them know of the incident, those events, all
Okay.
of those things.
So-
making sure someone would go immediately to the hospital with that individual as well.
Yeah, and I believe it was CO Pendergrass that went with him?
Yes.
Yeah. Was that at your order or
Yes.
direction?
Yes.
All right. So who decided to watch the video after it happened before you got interviewed? Was that your own decision, or were you told to watch it?
Well, I always review video after any incident happens. As a supervisor, I would review video.
Okay.
And then anything that happens that is significant, we'll do our chain of command. I'll let my captain know, and the sheriff, and everybody else would come and review it as well.
Okay.
When something significant along what happened along those lines, when that happens.
Okay. Did you do that in this case?
Yes.
Okay. And what did you tell? Do you remember the reason you called your who'd you call first, the captain or the sheriff?
I don't recall. I'm certain it would have been the captain because he's my immediate supervisor.
And who was that? Captain who?
Captain Blanc.
Captain Blanc.
Yes.
So so he wasn't working, or did you call him, or?
I had to call him.
You had
Yes,
to call him.
it was at nighttime. He wasn't working, so he had to be called in.
Okay. Do you recall what you told him?
I do not.
Okay.
I don't recall.
But there's a reason. So you were concerned.
Yes.
What were you concerned about?
I was concerned that we had an incident that resulted in a significant thing that happened with one of our then inmates at the time.
Okay.
So it was a very serious incident.
Okay. Were you also concerned at anything that you saw when you reviewed the video?
There were developments between officers that I saw where different things happened. Nothing specifically at that time immediately was any different other than letting my captain know and having them take a look at that video and come into a determination on the video.
What specific things that you're talking about that
Just different methods that officers use, whether it be
Yeah, come on. Mr. Odell, anything on that video that was against your training that was you were trained not to do, and as we've already talked about, that concerned you so much that was the reason you called your captain?
No.
Okay. So, and again, you said you saw the video, and you, during that video, did you see Officer Cooper's standing on inmate Rios's back?
Honestly, I don't recall. I do know that I did see him standing in upright position, but in terms of anything that would have been something I talked to my captain immediately about, I would not have noticed that unless our captain reviewed it and came away with the concern as a result of all of officers' use of force. But the primary thing was the safety of the inmate at that time.
Well, did your captain express concern after he saw did your captain watch the video?
Yes.
Did he express concern to you about that?
No.
You did not?
Objection, that's calling for a hearsay response.
Sustained.
Did you, before you were interviewed by Detective Radio, did you get together with the people, the other COs involved in the incident and talk about what had happened?
I don't know if we had an after-incident review where everyone was together. We may have a little bit, but mainly I think that I was in the supervisor's office talking with my direct supervisor and making sure everybody was called. So there were bits and pieces of interaction, but I don't know that we had an interaction all together afterwards.
Okay. And did the other officers stay? Longshore, Long, we know Pendergrass went to the hospital, right?
Yes.
Gartner, I think. Mahan, how do you say her name? Mahan, I'm sorry. Did they all stay?
That night, yes.
And did they all watch the video before they got interviewed?
I do not recall that because I don't make the video. As a supervisor, when we watch the video, I don't make that video. It's just, it's a supervisor reviews it and then our administration looks at it. So it's not something that everybody looks at that video, to my knowledge. No,
okay.
We wouldn't do that.
All right. You say they wouldn't do that?
We would. It would come from me. I would have the actual from the camera.
Yeah.
I would have to allow other officers to watch the camera.
Did you do that?
No.
Okay. I'm going to play the video now and ask it, and then I'm just going to let the whole thing play through, and afterwards I'm going to ask you some questions about it, okay?
Okay. All right. All right. I'm not going to call anybody unless you come down from down here. Okay, this is the last time I'm going to ask you. I've asked you for like 5 minutes. I'm not going to do it anymore. Okay? We're going to put you in a restraint chair for your safety due to not listening, be uninvited, or causing a risk to harm yourself. We don't have time to continue that all night. Okay? All right, this is the last time I'm asking you. We're going to go and we're going to go ahead and put you in the chair.
Why can't you just open the door?
Right here. All right. Come on down. No.
Handcuff.
Is that a yes or no? Go ahead and turn around, put your hands behind your back, and cuff up for me. If not, we're going to come get you. All right. No? Okay, we're coming to get you. Let's go. Go. Stop your back. Hands behind your back.
Come on, man. I know you're fighting.
Here's your taser.
I'm fighting.
Taser.
You take off. Taser. I'm not even fighting him. Ow! Glasses, let me come out them glasses. Taser. Ow! 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 All right. Ow! Ow! Can someone
tasing.
Can you explain to me? Because you're a dumbass.
Now you're the dumbass.
I didn't say you were her. Oh.
Fucking took out of himself.
Really?
Yeah, he's little.
Oh! Ah! Give your hand behind your back.
Oh, shit.
Somebody take it.
He's on some type of...
Keep playing.
You need to. We have anybody else with? Rios? Rios. Alexander Rios. Yeah, he thinks he's supposed to be out of here and he's bring it out on the wall.
That's safe. Cut it off, turn it off. Turn it off. Let go of the car. I'll fucking... Let go of the car.
Right up there on the wall.
Pull that thing out.
Get a pair of shackles.
Can we get another hit? Handcuff. Where's the other hand? I got it. Where's that? I only have one handcuff.
Do you want a pair of shackles?
Okay.
So I can't beside
me.
He's got it. All right. Grab some, oh, he's got it. We got shackles.
Ready?
All right. Yeah. Shackles.
Give me the other hand. Bring it forward, guys. You got it?
Shackling down there.
This club.
Number 2, babe?
You know, second. Where's the red?
Is this on YouTube, babe? Let's find his foot out there.
Where's that? Right. Everybody else in jump around the ankles? Do the ankles now, so. Keep on. Yeah, come on the other side of the lawn. When we come up, we're going straight up into the chair. All right. Cooper, I'll behind you. And Mark, behind you. I got you. All right, I got the chair so it doesn't. Okay. You two ready? Go on. Just turn it. Straight up. Get up.
He's turning blue.
There.
Call squad. Master control, call the squad.
One side. So give us some marks and make sure everything's going okay for him.
Mr. Riddell, is that the video you saw that night?
Yes,
Yeah.
I believe so.
And during that video, did you see Officer Cooper's foot on his back and at one point had both feet on his back, standing out?
Honestly, at that time, I
No,
don't
right here,
know that
right
I
here.
saw.
Right here.
In here? Did I see it?
Yeah,
Yes.
yeah, that's what I'm asking. I'm not saying during the incident. I know you were, whatever you were doing, right, busy with his feet and his legs, right? But I'm saying, after watching the video, you saw that, right? You saw him doing that. And then after he got off, he actually took his foot off, and then did you see what he did next? Did you see him kneel on the back of his back?
Yes.
And not only kneel, but put his left hand on the back of his, is that from your training, are you trained to do that? Are you trained not to do that, Mr. Riddell? And listen, I know Mr. Cooper's a friend of yours. I understand this is hard, but you gotta ask. You're trained not to do that?
Usually, I mean, we can get leverage, but it just depends. We can get leverage on a person when to make sure that they don't move around. We can do that.
At this point, now I'm talking about specifically when you saw Officer Cooper remove his foot and kneel on him and put his hand on him, right? I'm talking about that specific moment. He was not struggling anymore, was he?
He did not appear to be at that time. No.
Did you see him? Did you see his color? I mean, I know you read his feet. I'm talking about here in this video.
I did not see real good until the very end.
Okay.
Yes.
You agree with me? He was blue. I don't have anything else.
And for the record, you should say yes. Cross-examination, Attorney Boone. Oh, I'm sorry, Attorney Mayer.
Your recollections from that event. I'm also going to ask you some questions about background. Just about everything that we think is relevant to your testimony, okay? Have you and I met before?
I don't know.
Yeah.
I honestly.
All right. But you were working down at the jail for a long time, right?
Yes.
How long?
Since 1999.
Since 1999. And I believe you testified on direct exam that you've been acquainted with Mark Cooper for some time.
Yes.
Described yourself as friends.
Yes.
I'm guessing you got to know him probably not long after he started at the jail,
Yes. Yep.
which would have been roughly when?
Early 2000s, maybe 2003, 2004.
So not long after you.
Yeah.
And the both of you worked there consistently until your retirement,
Yes.
which was when?
For me, 2020.
Right. And because you're friends with Mark Cooper, you know that he continued to work at the jail after this event, yes?
Yes.
And you know that he continued to work at the jail after your retirement, yes?
Yes.
And because you're friends, you also know that Mark Cooper just decided to leave the jail to take another opportunity, correct?
Yes.
Okay. In other words, he was not let go. He was
Right.
not fired, right?
He was not, no.
He was not placed on leave, correct?
No.
Not your decision, right?
Right.
But those are the facts.
Yes.
Okay. Now, we're going to go through a number of different topics that you testified to and some that you didn't. But I kind of want to ask a question real quick. You were indicating that seeing the video gives you the opportunity to kind of have a perspective that you didn't have when the events were unfolding in real time
Yes.
on September 19th, right?
Yes.
Okay. And it's fair to say that when these events are unfolding in real time, it's not the same as sitting in that chair or any of these chairs or what this prosecutor was doing, taking you through a play-by-play and breaking it down, is it?
No.
What's different?
When the event's unfolding, you have a lot of different factors that are going on, and you're not going to see every development that's going on in real time. You're going to see what you've done and what you're hoping to accomplish from a secure standpoint, but you're not going to see in clear detail everybody's actions at every time.
Sure. And so, armchair quarterbacking, hindsight 2020, you're familiar with those terms?
Yes.
They both refer to situations where somebody can go back and maybe look at a video or look at a photograph and make decisions about things as to how maybe they were happening when you didn't realize that was the case at all at the time.
Yes.
All right. Was this the only use of force event that you were involved in the 20 plus years that you were at the Sheriff's Department?
No.
These things happen, right?
Right.
And they're serious matters, yes?
Yes.
Okay. And there are strict protocols to follow when you anticipate that a use of force event may occur, right?
Yes.
Were those protocols followed with respect to how you approach the cell, handheld and all that?
What happened there, that would be common with the situation we encountered as far as wanting to put in the restraint chair, or if we have someone that's running actively in our booking area, we would, if they're not cooperating, we would assist them to the ground so that we can gain compliance, shackle and cuff, and then place in a restraint chair.
In fact, the Richland County Sheriff's Office has general orders and directives that form the protocol for your policy and your training, right?
Yes.
You're familiar with those as a former supervisor, and you were familiar with them as they existed back in September of 2019, yes?
Yes.
Okay. This is going to be the B series, Judge, B1, B2, and B3. Okay. Okay, approach, Judge.
Yes.
Thank you. All right, Mr. Odell, I'd like you to take a look at these, I guess in order. Just take your time, as much time as you need. First is B1, B2, and then B3. Once you've looked at all of them, front to back, and again, take as much time as you need, let me know when you're ready to identify, if you can, what they are and answer questions about them, okay?
Okay.
I'll wait to hear from you.
Okay.
A little light reading for you. Do you recognize those three documents that are B1, 2, and 3?
Yes.
Can you tell us in order what they are?
This is restraint chair policy. This is the EID policy on non-lethal electronic immobilization devices. And
Tasers, for
the taser,
example?
yes. And the use of force and use of deadly force, or use of force continuum.
all three fair and accurate representations in their entirety as you recall them in place back in September of 2019?
Yes.
Okay. Now, you seem to take your time with that, so I expect you're ready to answer some questions. If I ask you something that you'd like to be able to look at it or refresh your recollection, let me know, and I'll ask the judge to allow you to take a look at it. I'm going to read from portions of it, okay?
Okay.
I noticed when you were reviewing, when you got to the last page of the use of force directive, you got to what essentially amounts to the only chart in the three documents, correct? And of all the pages you reviewed, you seem to spend about the least amount of time on that. Yes? Give or take. I'm guessing that's because you're very familiar with it.
Yes.
Okay. All right. So I want to kind of get back to where we were. We're going to talk about the video. We're going to talk about everything that you recall specifically, and then which portions that you see on the video as well. Okay? All right, so when you look to what would be B3 in front of you there, the last document that you reviewed, what you have identified as the use of force and use of deadly force policy statement, Direct General Order 24.8. Do you have that in front of you? Right there on page 1, in bold letters, it indicates a peniological interest. Yes? Do you see that?
Yes.
A peniological interest is the interest in the jail, or the jail's interest in making sure that use of force is done the right way. Is that fair?
Yes.
But specifically, it indicates peniological interest to provide reasonable and necessary force options when an inmate exhibits resistance, attempts an escape, is non-compliant to lawful instructions, threatens, or uses force. It kind of gives all the different examples that the order takes into contemplation as to what might justify use of force and how we should respond, right?
Yes.
Okay. And based on your recollection and being able to take a look at the video again today, hearing your testimony, it seems fair to conclude that Rios exhibited resistance, yes?
Yes.
It seems clear that Alex Rios escaped his cell, yes?
Yes.
It seems clear that he was non-compliant to lawful instructions made by the corrections staff, including yourself, correct?
Yes.
And during the course of the resistance, his behavior is threatening to you all. I believe you said that, yes?
Yes.
It's concerning as to your own safety and that of the other officers?
Yes.
And it was also concerning to his own safety.
Yes.
And to be clear, when you read the entirety of that document, it starts out by saying that use of force should never be punishment, right?
Right.
And that goal number 1 is the safety of the inmate, yes?
Yes.
Okay. As you were interacting with Alex Rios, starting from the moment the camera starts rolling until the time it finishes, anything you did, was it for the intent of trying to punish or otherwise harm Alex Rios?
No.
Okay. What was your primary objective from even before the camera starts rolling? Because if I understand, you were already engaged in trying to negotiate him off that wall, right?
Yes.
You saw him first in that cell when he was creating a verbal disturbance, right? And then he climbed up on the wall while you were trying to get him calmed down, right?
Yes.
So your attempts to get him calmed down, instead of having the desired result, he ended up climbing up on that half wall, right?
Yes.
Did that raise your concern for Mr. Rios' safety or lower it when he climbed up?
Raised my concern for his safety.
Sure. And why is that? Okay, I want to give you a full opportunity to answer that because you talked about that with Detective Radio and you started talking about it here. So
Yes.
please tell us.
So when he's on the divider, he has a risk of falling off of it, and he can harm himself much more than if he's in level ground. And based on his behavior, my main concern was to get him to come down so that I could talk to him. One, the main thing was for his safety. And when, through repeated opportunities to talk to him, when he did not comply to do so, and the things that he was saying, we realized that his safety and our safety was definitely in jeopardy at that point in time.
Okay. And so the option of just leaving him in the cell to see how it all played out was not an option, right?
No, it was not.
Because, of course, he's in that green smock, right?
Yes.
Which has been described as a suicide smock, right?
Yes.
One finds their way into the suicide smock either because of behavior that's concerning, right?
Yes.
Things they're actually physically doing, perhaps, that are concerning for suicide, right?
Yes.
Or the words that come out of their mouth, correct?
Yes.
And you know that in this case, Rios had communicated to other officers that he had thoughts of harming himself, right?
Objection?
If he knows.
Only if you know.
I don't know that.
Okay.
One way, among those others, that you can end up in the suicide suit in your 20 years of experience is if you communicate to an officer that you're going to harm yourself.
Yes.
Which one of those things or something else that caused Alex Rios to be in smock, you're not sure. Which one, right?
Right.
But what you do know is that's the type of thing that gets you in that suit, right?
Yes.
And when someone is suicidal, by definition, you have to be concerned for their safety, right?
Yes.
And that's why we don't just leave them in the pod with all the other inmates, right?
Yes.
If we do that, we're setting ourselves up for all kinds of problems because we're not paying attention to what the inmate is telling us, right?
Right.
And in the end, we have to protect the inmate above all else, right?
Right.
That includes when we become concerned that they may be suicidal, right?
Yes.
So we bring them down to the booking room, we put them in that gown, right?
Yes.
What is the purpose of putting them in that smock?
For their safety, so they cannot harm themselves.
Give us more. What do you mean by that?
So they can't use anything inside of the cell. So they can't use it as opposed to their own regular issue jumpsuit.
Stripe
so they
suit.
can't use it. Yeah, they can't use that to harm themselves in that way. Cut off their circulation.
Ligature.
Use it around their neck. Any type of material that could be utilized for that purpose. We want to make sure they don't have any of those items present with them at that time.
And of course, that's why when we're watching the video, we can tell that aside from the suicide smock, he's got nothing else on clothing-wise, right?
Right.
And that's for his safety.
Yes.
Because those garments could be used to harm himself in a suicide attempt.
Yes.
Okay. And that smock is specifically designed so that can't happen.
Yes.
Okay. So when he climbs up on that wall, and you already know that he's down there because he poses a risk of harm to himself based on the suicide concern. When he climbs up on that wall, yes, you're concerned he could fall off, like you said, right?
Yes.
He could also jump off intentionally and harm himself, correct?
Could, yes.
And if you do that, like Mr. Salisbury said, everybody got to go down and take a look inside that very particular cell. On the other side is the bathroom and a bunch of corners and edges and things like that,
Right.
right?
Yes.
And any of those are hard surfaces, right?
Yes.
People could do serious damage to their head and the rest of their body in an intended leap or an inadvertent fall, right?
Right.
And based on the behavior that he was exhibiting, did he seem stable to you?
No.
All right. Now, how long were you familiar with him having been down there before this event happened? You?
Not very long. Literally, I came on duty.
what time?
Went into the book. I would have been on duty at about 9:30, so 21-30 hours at that time. And when I went in there, I immediately noticed that his behavior was not right.
Okay.
And that not to respond would be indifferent in a way that would be harmful to him, so I had to respond.
It's fair to say that his behavior continued to escalate or deteriorate, depending on how you want to look at it.
Yes.
And so that it was making you even more concerned.
Yes.
Right? You talked about he was speaking in a way that suggested to you that he didn't know what was going on.
Right.
Right? Confused state?
Yes.
Fair? All right. And so you told the jury that you recall him making comments that he wasn't supposed to be there in that cell, right?
Yes.
Okay. To be clear, he was arrested on a valid warrant, and he was rightfully in the Richland County Jail, correct?
Right.
This was not some great big mistake made by everybody here in Richland County, and he was falsely imprisoned. He was supposed to be there, right?
Right.
All right. Now, with respect to other things he was saying, as you're in the booking room, I suspect this is what you're referencing when you talk about it in your interviews previously. He was also making comments as other inmates were coming in, one in particular, hey, that guy's got my stuff. Can you talk about that?
So I do recall that, and that didn't seem to suggest that made a lot of sense either, that somebody else would have someone's stuff, not in that, because he would have been there long enough for his property to have been secured, and that would not have been an issue that we would have been concerned about with this property.
Not taking anything for granted here. The booking room is where you bring me if I just got arrested, right?
Yes.
And that's where you inventory my stuff so that when you let me out, I got a piece of paper that says this is all my stuff and I can get it back, right?
Yes.
Okay. And so that process is happening in front of Alex Rios as he's in the booking room, right?
Yes.
And during one of these processes, he started making comments, that guy who's getting his stuff turned in, that's actually all my stuff.
During inside of there, he did make a comment, yes.
And that was just bizarre and didn't make any sense, right?
Right.
Okay. In total, you just described it as all very erratic behavior, and that's what we're seeing once the video starts, right?
Yes.
Objection.
Not asking the question. Conclusion. It's a conclusion, so you can rephrase it as to.
It's okay. Thank you. Now, we see the discussion going on for a little bit of time, maybe a minute or two. How long was the discussion going on before the camera started rolling, best of your recollection?
A few minutes.
Okay.
Enough for me to know that I wasn't going to be able to get compliance from him unless we took additional steps.
And when we talk about compliance, the jurors had an opportunity the other day when examining that cell, their attention was directed to the food flap. What is the relevance of the food flap as far as the protocol and procedures that were followed as it relates to trying to get compliance?
So they're given an order to turn around and be handcuffed through the food
I'm the
flap.
inmate. What am I supposed to do?
Turn around, put your hands behind your back, put your hands up to the food flap, and then an officer will come grab your hands and they will handcuff you.
So is the food flap open in and out, almost like a doggy door?
It does.
That kind of thing?
We unlock it with the key, and then it comes down and you put your hands through that.
Okay. Once I do that, what happens next if I'm compliant?
If you're compliant, once you're handcuffed, then you're instructed to go back into the cell. We close it up, and then we open the door up to take you and put you into the restraint chair for your safety with compliance.
If that process had been followed, would any of these other things happen?
No.
Any doubt in your mind about that?
No doubt.
And when you talk about him being non-compliant, that's one of the factors that you're talking about, right?
Yes.
In addition to just not coming off the wall, period.
Yes.
You talked about he was looking around up at the ceiling, you had concerns about sprinkler heads and so forth.
Right.
Why?
Because that's also a risk. One, lots of water coming into the cell, potential that inmate the cell being flooded out. Water could obscure his vision, knock him down, slip, fall. Again, another reason for concern. And pressing against the top there could also be showing intent to perhaps try to come out of the cell as well.
Okay. Now, you give the order to have the door popped, right?
Yes.
Before that happened, how did you get the other COs that you're supervising in position to be prepared for this? Describe that process.
So we had the restraint chair. I had officers that were present. I recalled officers on each side. And before I enter that door, I asked and instruct my officers if they're ready, that they're in position. And then once I know that that's the case, then we open the door up and then we go to get him with compliance if we can get him to come down. If not, then we're going to have to forcefully try to get him to come down from that divider.
Okay. And so you're prepared for, at least trying to be prepared for whatever happens next.
Yes.
To be clear, the man that you've identified as Mark Cooper, while all of this process is taking place, he's not there, correct?
Initially, I don't recall.
Okay. Now, with respect to video, of course, we've got the Sony handheld, right?
Right.
In the corners of the booking room, there's also little glass balls that are like that one up there that are cameras, right?
Yes.
And you know that there's other video showing all those different angles, right?
Yes.
And you've reviewed those as well, correct?
I've seen them.
Does it refresh your recollection in having me remind you that Officer Cooper could be seen running into this situation after Mr. Rios is already down on the ground and wrestling?
I don't recall.
It's okay. We'll look at those videos later. And it's difficult to recall because of the passage of time, for one, right?
Yes.
And also because you were doing very specific things that are easier to recall than what other people were doing.
Yes.
Fair? Okay. Now, when the doors popped, describe what happens next in your own words.
We see the inmate, we see him come off of the divider. He runs down pretty quickly to our surprise, and he's able to press past one of our officers in position to gain free access into the booking room.
How quickly did that happen?
Very, very quickly.
Right.
Like, I've never seen anything like that before.
Okay.
In my time there.
20 years.
In my 20 years, yes.
All right. And so now, Mr. Rios has broken detention, correct?
Yes.
He has escaped his cell, correct?
Yes, he has, yes.
That's correct description based on your training, right?
Yes.
All right. Now, it was mentioned to you on direct exam that there was nowhere for Mr. Rios to go. Do you recall that?
Yes.
I heard you say, well, he's in the book-in room, right?
Yes.
There's all sorts of items that are just laying around in the book-in room, right?
Right. Yes.
Anything in a hostile situation can turn into a weapon, is that fair?
Can be used as a weapon, and there's also buttons that can help you get out of said area.
Sure. You also mentioned that without someone pressing one of those buttons necessarily, he's not able to just go open those doors, right?
He's not able to.
Right. Because a jail is a secure place, right?
Right.
And it's a place of rules, yes?
Yes.
The rules are important for the protection of the inmates, yes?
Yes.
And the protection of the officers, right?
Yes.
And everyone else who works there, correct?
Yes.
Got nurses and all sorts of other types of people, food workers, etc., right?
Yes.
And just outside that book-in room door is the open hallway where you can find all those different areas, right?
Yes.
And you can run into those areas without having to push buttons, right?
Yes.
You indicated that if someone simultaneously was coming in, a door would be open, right?
Right.
And the book-in area is a high-traffic area. It's the nerve center of the jail, yes?
Yes.
By definition, when people are being arrested, that's where they're brought, right?
Yes.
Another area, which would be a point of ingress or egress from the jail, would be the sally port, right?
Yes.
What's the sally port? Tell me.
It's basically the area where they would bring in cruisers or anywhere. It's basically the last line of defense before you're outside the door.
Yeah. You leave the booking area and you're
Outside, like free.
Open air.
Yes.
Right? So that's not far from there, right?
Not far.
And when you talk about other people coming in during this event as a concern of yours to him escaping all the way, right? You mentioned that. Who is Officer Boyd?
He's a deputy.
Right. What's his rank? Just Deputy Boyd?
Lieutenant. He was a lieutenant, to my knowledge, at the time. Yes.
Right. In fact, he arrived in the middle of this event from the sally port, correct?
I don't believe it was a sally port.
Where did he arrive from?
I think it was our main hall area.
Okay.
He arrived from, yes.
So he arrived during that time, right?
I believe he may have, yes.
Okay.
I don't recall.
Fair. If I showed you your statement at some point, talks about him going to get leg shackles and things like that, does that sound familiar to you?
I don't recall.
It's fair. All right. I appreciate you doing the best you can. All right. When you look at the guidelines, we're going to stick with the use of force continuum for now. Page 2. Under procedural guidelines toward the bottom.
Yes.
In the context of use of force, whether it's describes conditions under which resistance, force, or deadly force may be used, emphasizes the need for an application of a particular level of response. Do you see that portion?
Yes.
It goes on to say, most often, such a thought process requires split-second decision-making under very trying and stressful conditions. I already see you shaking your head yes. Why are you agreeing with that?
Because that's exactly how it is when we're dealing with a situation that is a high stress level event.
What makes these events high stress?
Not significant levels of non-compliance and things that happen that are far out of the norm of what we would normally tactically respond to.
Is it fair to say that there's a degree of uncertainty amongst officers as to how these things are going to end?
Yes.
When these restraints and uses of force are happening, are you concerned for your own safety?
Yes.
Why did you switch out with Mayhan? She's a
Because
CO.
of the concern behind what we saw. I saw that officers were at risk of potential harm, and I made the decision to put myself in that situation to help because of the potential of risk of harm to our officers.
At that time, weren't there already 4 or 5 officers involved?
Mm-hmm. There were, yes.
Why do they need you? Tell us.
Because it did not see based on what we've seen presented by that individual. We saw an unusual amount of strength and determination, and whatever we were using was not working and I immediately knew that I needed to get involved to help to gain compliance with this situation.
We watched that video with you. If you want to see it again, please let me know. Okay, I'm not trying to keep it from you, all right? We can roll the whole thing again. So if this doesn't go along with what we just watched or your recollection, you correct me, okay? But what you would have been noticing during the time before you decided to get involved, right, is a situation where Alexander Rios is actively resisting, right?
Yes.
If you refer to page again 2 of your use of force continuum, just above there, you have a definition section. Would you agree with that?
Yes.
The last one before you get into procedural guidelines is active resistance. Yes? Could you read that out loud and tell us if that's how you understand and understood active resistance, that definition back then?
Active resistance. A subject actively resists when they take affirmative action to defeat an officer's ability to take custody or control.
The moment he comes bursting out of that cell like nothing you say you ever saw before, was he actively resisting at that point?
Yes.
Once he got to the ground as a result of some of the wrestling, does he continue to actively resist?
Yes.
Eventually, you made the decision that the officers that were working, it sounds like, weren't able to gain control of him.
Yes.
They were using body weight. We can watch it on top of him. They've got him on the ground. He starts on his side. He gets down on his belly in a prone position. You would agree with all this based on the video, right?
Yes.
We see officers, all of them, using leverage and using their body weight on his back in order to try and gain control of him, correct?
Yes.
You've talked about identifying Officer Cooper as being the officer about 2 minutes and 50 seconds in who gets both feet up off of the ground on his back area, correct?
Okay.
Give or take?
Yes.
Prior to that, we have other officers, very large men, that are also using body weight on his back, torso, legs, head, anywhere they can to try and gain leverage on him to gain compliance. Fair?
Yes.
Do you know Officer Nate Long?
Yes.
If you walk through that door, he'd be a big dude, right?
Yes.
Bigger than Cooper, right?
Yes.
He's a mountain. Fair?
Yes.
All right. Longshore's not a small guy, is he?
He's tall.
Okay. Not compared to Long, right?
Right.
All right. The point is, these are full-grown men that are exhibiting leverage and all of these different techniques in order to try and gain control of Alex Rios, right?
Yes.
You're watching this with the hand, you have the hand held up until you don't, right?
Right.
And it's your decision that they just aren't winning.
Right. Yes.
So eventually you go hands-on, right? Has the taser been deployed, yes or no, at this point?
Initially, no.
Okay. So once you're hands-on is when the taser starts being deployed?
A lot of different things, including deployment of taser, yes.
You watched the video. Officer Prender also had his taser out, right?
Yes.
You see the portion where Alex Rios was grabbing the taser?
He was grabbing the taser, yes.
What's the concern when an inmate...
That he could overpower the officer and he could take over the taser and use it on officers at that time.
Right. You have a word for that, don't you? What are they trying to do in that moment?
Trying to harm officers at that
Right.
point.
Are they potentially trying to disarm the officer?
Yes.
Of the taser?
Yes.
1 to 10, what's your concern level? 10 being super concerned about that.
That's a 9-10 concern level.
Right?
Yes.
Okay? Now, we know that the tasing that occurred in this case was a couple different kinds, right? So let's learn about tasers a little bit. Can we do that?
Okay.
All right. You're gonna go use your taser. You're gonna go use your taser, right? There's 2 ways you could deploy that. Yes?
Yes.
All right. Most people think of, I'm gonna shoot the taser at Boone over there, and if the prongs that protrude are gonna have wires, correct?
Yes.
And if they get in him, those prongs are hard to get out, right?
Right.
Kind of like fish hooks almost? I don't know.
Something, yeah.
They're designed that once they get in there, they're hard to get out, right?
Right.
Sometimes you have to, if you're inadvertently tased, you might have to go to the hospital to get it taken out.
Right.
The wires conduct the electric shock to the prongs, is that fair?
Yes.
The wires, when the taser's deployed, meaning taser, as opposed to the tasee, the person who's shooting the taser, does he control when the electricity hits based on a trigger?
He shoots it, and then, yes.
Okay, so I want to understand this, okay? So you tell me. So if I'm tasing someone who's standing at that door,
Okay.
using the probes and the barbs, and I shoot it and the probes go in, is the person going to feel the electric shock as soon as the probes hit them, or do I have to do is there a separate action that causes the electric shock to conduct?
Well, once it's been deployed,
Yes.
It's going to go through its process. So
Yes.
soon it's going to
A
take,
cycle.
Yes, it's going to
Okay.
go through its cycle at that point.
Okay, the cycle will end.
After 5 seconds,
Okay, am I done tasing? Do I have to go get another taser if I want to do that and then do the process all over again? Or as long as the probes are in, can I cycle it again? If you know.
I don't recall.
Fair. The wires themselves during the tasing when it's cycling, if I grab one of those wires, am I going to get an electric shock?
I don't recall.
If you know. Oh, fair. Okay. But to be sure, the taser is a pain compliance technique, correct?
Yes, yes.
Can you tell the jury what a pain compliance technique is?
It is a brief interruption, a technique to get a brief interruption so that then you can gain compliance of that subject.
The idea being that the normal person, when they get tased, doesn't like that,
Right.
and whatever they weren't doing before, they might start doing now to get in compliance.
Yes.
Like cuff up.
Yes.
Okay. Did the taser appear to be having the desired effect on Mr. Rios?
No.
Now, you indicated that's one way a taser can be used and how most people might think of it. There's also the so-called dry stun or drive stun. I've seen it both ways. Do you know how it's actually...
The drive stun?
Like
As in
drive directly on you?
Yes.
If I understand the drive stun process, I remove the cartridge that would have the barbs and the hooks in it, prongs, probes. I can set that down, and now I can put this up against the person who I want to tase, and there's an electric current that kind of goes right there,
Yes.
right?
Yes.
We can see that process happening on the video between Officer Prendergast and Mr. Rios, right?
Yes.
And we can also see the struggle over the taser that's happening before that, right?
Yes.
Or after. And we see the area that is drive tased, I think is at the shoulder blade or the back of the neck. Is that fair? If you know.
I don't recall.
Fair. But you recall those two separate events going
Yes.
on with the taser,
Yes.
right?
Yes.
And it was before or after that you think you put the camera down and got in?
Before.
All right. You know that from watching that video and from that night, and probably just even in real time because you're holding the handheld, when the taser was first deployed, one of the prongs went at Rios, and the other prong inadvertently struck my client, Mark Cooper, correct?
Yes.
Where did it get him, Mr. Cooper?
The finger, I
Yeah.
believe. Is
Right, the webbing of the hand there?
Yes.
Have you ever been tased?
Yes.
Painful, yes?
Yes.
Okay. And you can kind of see that in Mark Cooper's reaction on the video, yes?
Yes.
And it's kind of right as he enters the fray, right?
Yes.
Comes in, taser, he's hit, he walks away from it, right? See that on the video, yes?
Yes.
All right. Then he re-enters. Now, you talked about training and placing weight with feet on backs and things like that, right?
Yes.
Okay. Can you show me anywhere in that use of force continuum where it says that an individual cannot use their foot for leverage on a back in a restraint situation?
It's not on there.
All right. Can you repeat that?
It's not in here.
That thing's 9 pages long. That's it, right? That's the policy. That's the training, right? And that's what was in effect back in September of 2019, right?
Right.
Okay. Now, if I'm an officer, right, that's got my hand tased, I can just call it a day and quit helping out, right?
Right.
Theoretically. Or I can still try and be actively involved in trying to gain compliance, right?
Yes.
Sort of lost use of the hand, right?
Yes.
Okay. And so do you draw any correlation between that and the use of the feet instead of the hands?
Judge?
I can withdraw. That's fair. Thank you. With respect to using leverage and weight on an individual's back, torso, anywhere, okay? What you're doing is trying to gain control of someone who is doing everything they can in this circumstance to work against you, right?
Yes.
How is it that you can gain control of a person? He was not pain compliant, correct?
Correct.
What do you mean by that?
That it had no effect on him and he continued resisting.
That's not just the tasing, right? It was also wrist locks and joint
Everything.
manipulations.
Yes.
There were also some strikes that were used as well, correct?
Yes.
Okay. And so, unless we just want, and we could see on that video, a couple times he's up to his knees and starting to raise up, right?
Yes.
When you got hands on him, were you able to tell firsthand what you described as this abnormally incredible strength or whatever it is that you described it as? When is it you noticed he had increased strength?
Well, I knew when we had some of our strong officers that were trying to gain compliance when it wasn't successful early on, I knew that we had something. Basically, at the time that I chose to hand over the camera, that's when I knew.
And once you got involved, did it confirm that suspicion that it appeared?
Absolutely, yes.
All right. So you also noticed once you got hands on, man, this guy's
Yes.
exhibiting. He's one guy.
Yes.
By the time you get in there, how many officers are involved?
I don't recall.
Okay. When we watched the portion here that the prosecutor directed you to, where my client is seen lifted his other foot up the back area of Mr. Rios that goes on for 7 seconds, you can also see that there are officers also leaning on his torso, right?
Yes.
Okay. All right, I want to get into the continuum itself, okay?
Okay.
And so I'm going to direct you to page 3, all right? And then we can also, if you want, you can just pull out the back page as well, since those, ask me, or let me know, do you agree that pages 3 into 4, section E, the use of force continuum, that sort of goes hand in hand with the chart, I guess the flow chart almost, that is illustrated at the back end on page 9.
Yes.
All right. So let's kind of deal with those, I guess, together. All right. So as I look through that, am I correct in stating that each level has a corresponding color?
Yes.
Level 1 is your blue, level 2 is green, level 3 is tan, level 4 is orange, and level 5 is red. Is that accurate?
Yes.
And I suspect if this chart that I had a color copy component to it, when I printed it out, it would probably have come in those colors, the chart itself, right?
Yeah.
That correspond with what I just read.
Yes.
Fair to say that each color or each level is representative of a different type of behavior that an inmate exhibits, and then you have a corresponding response level when it comes to force.
Yes.
Okay, so let's kind of start from the bottom, okay? Level 1, we speak of an inmate who is passively resisting. You see that?
Yes.
This inmate is not responding to commands, verbal or physical danger cues. He's perceived by the officer to be passively resistant. Do you see that?
Yes.
That's not defined earlier, but I'm assuming we're going to think that is like the opposite of actively resistant.
Right.
Okay, and it stands to reason that the level of force that goes along with that to meet a passively resistant inmate is going to be the lowest level of force.
Yes.
When we see inmate Rios in the cell, would it be fair to say that he is falling into category level 1 a little bit?
Yes.
Okay. All right. When we get into level 2 green, and that's why if you open the door and Mr. Rios had simply climbed off the wall and stood there, y'all couldn't tackle him and then start trying to gain leverage on him and all those things because he's not actively resisting.
Correct.
He would almost be doing exactly what you asked him to do.
Yes.
And of course you wouldn't respond with a higher degree of force.
Yes.
Okay, so let's talk about level 2 green. The parenthetical immediately refers us to inmate is actively resistant. Do you see that?
Yes.
And we just talked about what the definition of actively resistant is, right?
Yes.
That's what we're talking about. The inmate is perceived by officers to be actively resistant. He is pulling away from the officer. He is refusing to move or dead weight, right?
Yes.
Okay. So in this particular circumstance, Mr. Rios, he sort of goes beyond that when he runs through officers, right?
Yes.
Okay. But even still, at a level 2, the officer responds, right, just for pulling away from an officer. That would mean, hey, come here, inmate, and grab the arm. It's like, get away from me. Just that. Or, inmate, we got to take you down to bookend, and then it's just like this. It was dead weight, right? If that's the level of resistance, on level 2, your response can be balanced displacement, right?
Yes.
What's that?
Where you get him off balance in order to gain compliance, basically. You can...
Sweep the leg, Johnny? I mean, what are we doing to do that?
Yeah, any number of things that will get him off balance.
Get him to the ground.
To the, possibly to the ground if you need
Sure.
to. So.
Stunning, striking muscle groups is contemplated in level 2?
Yes.
Takedowns, joint manipulations, or pressure points, yes?
Yes.
This is the threshold for any reasonable correction officer to consider this inmate to be dangerous or a threat to himself, yes?
Yes.
Compliance techniques may include all reasonable means to bring the inmate into compliance as soon as reasonably possible, yes?
Yes.
These include restraints, forced movement, forcing an inmate.
Judge, I was just reading the whole policy and not asking any questions. I mean, the exhibit is going to speak for itself whether it's admitted or not. He's already identified and said that is the exhibit.
I'll ask him a question.
Okay, please do.
Okay, directing your attention down to the bottom of the level 2 response. I'm going to read a portion and ask you a question about it, okay?
Okay.
Once inmates are perceived as actively resistant, officers should not relax care until the subject is fully secured and in an isolated cell.
Yes.
Is that consistent with your training in 2019?
That's consistent.
Okay, now let's break that down. We've already talked about what actively resistant is, correct?
Yes.
You have defined inmate Rios as being actively resistant, yes?
Yes.
Any doubt in your mind about that?
No.
You should not relax care until the subject is fully secured. Let's talk about fully secured. Fully secured means cuffed, yes?
Yes.
And in an isolated cell, correct?
Yes.
In this circumstance, fully secured meant cuffed behind his back with the leg shackles. That was the plan,
Yes.
stated intention, correct?
Yes.
And then placement into what would be the restraint chair,
Yes.
right? Level 3 TAM. Tell us what level 3 inmate is what?
Assaultive and a threat to bodily harm.
What types of behaviors can the inmate exhibit to fall into this category?
So he can be wrestling with the officer or pushing the officer. We're perceiving him to be assaultive, a threat to bodily harm. Behavior may be directed toward a fellow inmate, another victim, or an officer.
And without having read that into the record during direct examination, isn't that exactly how you described inmate Rios?
Yes.
Okay. And so, with respect to a level 3, the officer's response is included but not limited to, and you would have the exhibit striking and punching, yes?
Yes.
Use of baton,
Yes.
electronic stun device,
Yes.
and immediate defensive tactics, yes?
Yes.
Including impact weapons.
Yes.
What are impact weapons?
Well, since we don't have any, we think about like the baton and things of that sort. We could use less lethal.
But, so even though the policy allows, it's not something that you have there at the jail.
Right.
Okay. In addition to that, hard fist.
Yes.
All right. And any other reasonable means available to stop the aggression at hand, yes?
Yes.
And bring the inmate into compliance, right?
Yes.
Is this why you hesitated when you talked about the use of leverage and things of that nature? And placing weight on the back of the inmate? Yes?
Right. Yes.
In other words, do the circumstances dictate what is appropriate?
Yeah. Yes, they do.
And just like the statement indicates at the beginning, these are split-second, high-stress, adrenaline-filled moments, yes?
Yes.
The last sentence of that, I'd like you to read the portion as it talks about level 3 TAM, beginning with, "It is contemplated."
It is contemplated and understood that reasonable officers, while employing defensive tactics, may cause injury, serious injury, and in some isolated instances, death, without intending such consequences.
As soon as you all realized that Alex Rios had lost consciousness, what did this immediately transition into with respect to the response of the corrections officers?
When we noticed this, it was immediately the AED call for the squad because the medical care component, we noticed this was an issue and we wanted to do everything that we could for his well-being at that moment.
Fair to describe that as life-saving measures?
Yes, absolutely.
That involves CPR?
Yes.
Did that also involve use of a device called the AED?
The AED, yes.
Tell the folks what that is.
Yes, it's a device that you hook up and you try to get, when someone's rhythm and they're not breathing, it's to try to get that heartbeat back and get them back to functioning at that point in time.
All right. And is it your recollection that correction staff, including yourself, did everything within your power to provide aid and medical care until the medics showed up and took over?
Yes.
And of course, the medics are more experienced in that area.
Yes.
Okay. And that's level 3 tan, right?
Yes.
Level 4 orange speaks as to inmate is assaultive or causing bodily harm, striking or kicking the officers, perceived by the officer to be assaultive. Yes?
Yes.
Wrestling and active resistance and these types of things are concerning for that. Yes?
Yes.
All right. With respect to a level 4 response, a number of different responses are appropriate. Yes?
Yes.
I want to speak last about level 5. Okay. Can you read to us the parenthetical for level 5, red in parentheses?
Inmate is assaultive and threat to serious bodily harm or death.
Okay. And this is like what would otherwise justify the most serious response as far as use of force. Is that fair?
Yes.
Okay. Well, if you could you just read to me the circumstances that would otherwise justify use of force at the red level?
It says inmate using a weapon against an officer, attempting to disarm officer, life-threatening weaponless assaults. The inmate is perceived by the officer to be assaultive, serious bodily harm or death, or attempting violent-based escape.
Based on your testimony here this afternoon, you have indicated that Alex Rios did escape his cell, yes?
Yes.
And was heading toward exit doors and running around the booking room in an effort to break detention, yes?
Yes.
Also, while previously indicating that he wasn't supposed to be there.
Yes.
Okay. Does, when your guidelines talk about attempting violent-based escape, do they talk about the likelihood that the escape will be successful? Do you see that anywhere in there?
No.
Regardless of the likelihood that Alex Rios was ever going to make it outside, okay, is the threat still the same with respect to what's going on?
By definition, yes.
Okay. Of course, you mentioned attempting to disarm an officer as well?
Yes.
All right. Officer Prendergast was armed with a taser, yes?
Yes.
It doesn't talk about disarm firearm, disarm knife, it just says attempts to disarm the officer, correct?
Correct.
In these circumstances, in a level 5 situation, the appropriate level of response is deadly force, yes?
Yes.
Okay. Now, when you look at page 9, okay, we have some different characteristics, both, I guess, that would apply to the staff members and the inmate factors. Do you see those at the middle portion underneath the chart?
Yes.
Okay. With respect to inmate factors, Mr. Rios is 27, 28 years old, correct?
Yes.
We've heard testimony at the time he was 5'10" and 194 pounds. Seem about right? You don't know. Fair. Seem relatively fit to you?
Yes.
All right. And relative strength is one of the factors.
Yes.
And you've already talked at length about that
Yes.
and the increased degrees of strength that you noted with him. Yes?
Yes.
All right. Have a moment, Judge.
Yeah, it might be a good time for a break anyhow.
Yes, sir. Thank you.
Ladies and gentlemen, 10-minute break, same instructions as all.
Did you say I could go, Judge?
Go right ahead, continue, please.
Didn't hear. Last question for you, Mr. Odell. If you could look back again, as you have been, at the use of force continuum. That would be section E, page 3. Are you there?
Yes.
It continues on to page 4, doesn't it?
It does.
And there's a little letter F at the top of page 4 that kind of finishes off that section, yes?
Yes.
Okay. I want to ask you about that passage. It reads, "It is important to remember that almost all incidents faced by officers are not scripted, easy to understand, or predictable as to the outcome."
Yes.
The incident that we have watched here in court today, that you've testified about in great detail, how would you describe that incident as it compares to that statement?
I would say that's exactly what it was. Yes.
And so specifically, it was difficult to predict what the outcome was going to be.
Right.
And you've talked about the risk associated with this in great detail.
Yes.
It's a dangerous job, right?
Yes.
Mr. Odell, I really appreciate you coming in today, and I don't have any other questions for you at this point. I think Mr. Salisbury may have some follow-up with you. I'm going to clear my things away, okay?
Okay.
I'm going to leave those exhibits up there with you.
So Mr. Odell, with respect to that last sentence that was just read about being unpredictable and you can't predict the outcome, right?
Yes.
That's life, right?
Yes.
That's everyday life for everybody, right? And that's exactly why, isn't it? Would you agree with this? Isn't that exactly why you receive such extensive training as to how to react in these situations?
Yes.
Wouldn't you agree? I mean,
Yes.
and even there was a section in there that I read that says that people that aren't trained on the use of force should not participate in anything like this. Is that?
Yes.
Do you remember reading that in there?
Yes.
Do you agree with that?
Yes.
Because they might react inappropriately because they're not trained. Do you think that's the reason, or that's a good reason?
Yes.
Okay. Mr. Mayor asked you about where do you see it in that B3, Exhibit B3 we're talking about, the continuum on force. Where is it in there that you can't put pressure with your foot on somebody's back? And you immediately said it's not in there, right? It's not in there, is it?
No.
Where is it? What could turn to the page that says you can't take both hands and wrap them around an inmate's neck and choke the life out? Where does it say that in there?
It's not in there.
Of course it's not, right? Because there's not an exhaustive list as what you can't do in that continuum, is it?
No.
Okay. Because it's not in there does not mean it's appropriate or trained, does it? I mean, that's why you get the training.
Yes.
Correct? Okay. And again, you were the lieutenant, so would you say out of that group of folks that were the COs, I shouldn't say folks, out of the COs that was in that group that's trying to restrain Alexander Rios, that you were the in charge?
Yes.
Okay. You were their boss, right?
Yes.
And it also says in that continuum that when you use deadly force, you have to announce it, right? Does it say that in that? In that B3?
Announce that you're going to use deadly
Yeah.
force.
Did you read that in there?
So where are we looking in?
I don't know what page it's on, but let's talk in the section that talks about the use of deadly force. the section on page, so I'm looking at page 5 of 9 on exhibit B3. Right? I was going to say you need to announce, you should announce when appropriate, the use of deadly force before using it.
Okay, verbal warning. Okay.
Go ahead.
Yes.
What does it say? So I don't misstate it.
This is verbal warnings are given prior to use of firearms if reasonably possible.
Okay. And it was not decided, you did not think use of force or use of deadly force was necessary in this case, did you?
If you can't answer, I don't want you to give opinions. So.
I can't answer that.
Well, you were involved in the incident and you did not use deadly force, did you? You yourself did not use deadly force.
No.
So one can reasonably assume from that that you did not think it was necessary in this case. Or else if it was necessary, you would have used it. Is that accurate?
The use of a firearm? If I would have announced the use of a firearm?
The firearm is not the only kind of deadly force. You would agree with that.
Right.
Right?
Yes.
Do you agree with that or not? Okay.
I would agree with
There's
that.
other kinds of deadly force. Okay?
Yes.
So we agree on that. So no, I'm not just talking about firearms. I'm not just talking about that. I'm talking about the use of deadly force. Did you think it was appropriate? Did you think it was necessary to use deadly force? Being that you've already answered that you did not use deadly force in this case.
I'm going to say fifth on that. I'll take the fifth on that.
Okay. Mr. Rios didn't have a weapon, correct?
Right.
Didn't have a knife or gun.
Right.
He never gained control of that taser, did he?
Full control?
Full
No.
control. He never tased an officer, did he?
No.
And in fact, couldn't it be a reasonable response to him being tased that he wasn't trying to gain control of the taser, he was trying to stop himself from being tased? Wouldn't that be a reasonable conclusion of what he was trying to do? It's not a fun.
Actually, it calls for speculation.
It does, sustain.
You've been tased, you said. Is that part of the training? I know it used to be. I don't know if they do that anymore. That you have to be tased before you can use a taser.
It's been where you could be tased and also as elected you can or can choose not to, but I was tased. Yes.
Okay, that's part of your training.
Yes.
Not because you did anything wrong.
Yes.
All right. Extremely uncomfortable, isn't it?
Yes.
I mean, not something to be taken lightly, and you would want to ever go through again, I assume. Is that a fair statement?
Yes.
Okay. And so when you get tased, that's the reason for the taser, you're supposed to react, right? Or not react, or comply, right?
Can you repeat the question again?
The reason for the taser is to get you to comply, to either react or stop reacting, right? React mean, okay, I'm going to get cuffed up, or I'm going to stop resisting, whatever it is, right?
Yes.
And that's why you announce it, right? So we heard that on the video. Taser, right? That's so everyone knows that someone's going to be deploying a taser, correct?
Yes.
Including the decedent. Okay? Right?
Yes.
He said it loud enough that was heard by everyone in that room, correct? Taser. Right? Yes?
Yes.
Okay, that answer out loud. But as an officer in that fray, you do not expect to be tased. Is that a fair statement?
Repeat the question again.
as an officer, as a CO in that fray, you do not expect to be tased yourself as an officer.
Correct.
Okay, so it's a fair assumption to say when Cooper got hit with the taser, it was surprising. It surprised him
Yes.
because he wasn't expecting to get tased.
Yes.
And you've been tased.
Yes.
The reasonable reaction is anger, isn't it?
Objection. It calls for speculation as to what Cooper felt when he.
I didn't ask what Cooper felt. I said it's a reasonable reaction.
It would be as to his experience. So you can answer as to your experience when you were tased.
Was I angry when I was tased?
Not you, because you expected it. I'm saying since you've had the experience of being tased, if you were unexpectedly tased.
Well, that's different. I object.
Okay. Only if you've had that experience.
Unexpected.
So I don't know, he would have to speculate to decide what his thought would be if he was unexpectedly tased.
So you saw the video, correct?
Yes.
And you saw Cooper walk away and rip the wire out of the taser, right?
During the video, I don't recall.
Okay. Well, you recall the end of the video, he didn't have the wire in his hand anymore, right? So somehow it got ripped out.
Okay.
Somehow the wire got disconnected, right? Would you agree with that?
I didn't see the very end where it was out, but
Oh.
if it was out, then yes.
Okay. So he walks away. What's the first thing he does when he returns from, if assuming that he ripped the taser wire out, what's the first thing he did when he came back to that pile? What's the first thing he did?
I don't recall.
He stepped on his back. He stepped on Rios' back, didn't he?
Okay.
Okay. And that is something that you and he, we can assume, have been trained not to do. You've said that earlier. That hasn't changed, has it? You said you were trained not to do that.
Under normal circumstances, no, we would not do that.
And you did not do that. Have you ever stood on a man's back?
No. Not in how we describe, no.
Okay. Well, what is it? Well, what do you mean? Have you ever stood on a man's back? That was my question.
No.
Okay. I don't have anything for it.
I'll vote yes. Okay, so Attorney Salisbury went through a couple of examples with you. One specifically that does not appear in here as a type of use of force that is prohibited. Do you remember that? I'll ask it this way. Do you remember when he said, it doesn't say in your use of force continuing that you can't grab a hold of someone's neck and choke them,
Yeah.
right? You remember that? And it doesn't say that you can't do that, right?
Yes.
But if you look to level 4 on the use of force continuum, let me know when you're there. That's page 3 of 9. Yes?
Okay.
You'll recall level 4 orange. The inmate is assaultive and causing bodily harm, striking or kicking the officer, perceived by the officer to be assaultive.
Yes.
You've already testified that you perceived Rios to be assaultive, yes?
Yes.
The officer responds. Can you read it? Reasonable response.
Non-traditional impact weapons.
Okay.
Less lethal munitions, baton strikes, use of sleeper hold.
Wait a second. What? Now, a sleeper hold is a choke hold, right?
Objection.
If he knows, only if you know what a sleeper hold is based on your training.
I don't recall.
Do you know what a sleeper hold is? Do you know how to apply one?
Yes.
Show me. Come get me. Come on. Demonstrate. With court's permission.
You can demonstrate on him, you can do so.
Okay.
I don't think you really want to put him to sleep.
I'll go pro wrestling style. Go to 3, then I'm out.
But come back behind.
Okay.
Can you read
Now, wait. Whoa. Now, where are you applying pressure?
underneath?
On my neck, right?
Yeah.
Okay?
With what? Objection. Not with his hands, it's what my question was.
That's fine.
Well, for the record, since you're demonstrating, we'll have to put on the record what the demonstration is, but go ahead.
Why don't you just take step by step what you're doing with your arms and where you're applying them, please? Is that fair, Judge?
That's fair.
Okay. We're almost done. Get me.
So I'm coming underneath.
Okay.
It's the
Underneath
neck,
what?
It's underneath the neck area.
Yes, sir.
It's underneath the neck area.
Okay.
And then I'm applying pressure until
Until I do what?
you pass out.
Right. And that's as a result of me being asphyxiated or choked, right?
Yes.
And under your use of force continuum, that is, does not fall under even the deadly force category, correct?
Correct.
That's level 4 orange.
Yes.
And so while it is true that the manual does not contemplate prohibiting 2 hands around the neck, right? It absolutely contemplates
Yes.
what
That-
appears to be a safer
Yes.
chokehold, which is a sleeper, right?
Yes.
And why is that safer? You know? If you know.
I want to be accurate, so I'm going to say I don't recall.
That's fine. All right. So not only does the continuum contemplate a sleeper hold or a chokehold type move, but it specifically tells you when you can use it, right?
Yes.
And it stands to reason that if you're using it at level 4, orange, that's the level before you get to deadly force, correct?
Yes.
And that's your training.
Yes.
Now, you were asked questions about the taser and disarming, right, as it gets you to deadly force, right?
Yes.
You asked a number of questions about that. Asked about he never gained control of it. Do you recall that?
Right.
And ultimately, he never did wrestle it away from Officer Prendergast. You would agree with that, correct?
Yes.
But if you look at your training again, words matter, page 3 of 9. Level 5 red. Response deadly force. You read this into the record earlier. I want to be clear on it. As it relates to the disarm the officer section. Let me know when you're there.
I'm here.
What is the full passage when it comes to disarming an officer that would justify deadly force?
Attempting to disarm life-threatening weaponless assaults.
Okay.
The inmate is perceived by the officer to be assaultive, serious bodily harm or death, or attempting violent-based escape.
Yes. And going back up to the disarmed officer passage, the words are attempting to disarm an officer, correct?
Yes.
That's the effort to disarm the officer, correct?
Yes.
And so what that tells you as a corrections officer in 2019 is I don't have to wait for the inmate to disarm me before I can start doing stuff in response to that, right? And that's just reasonable, isn't it?
Yes.
Because once we wait to be disarmed, all bets are off now, right?
Objection.
It's more argument, so it's just
But again, once that attempt to disarm the officer occurs, it lends itself to that situation that is contemplated, where these are split second, the outcome is unclear, and they are characterized by split seconds, excitement, and adrenaline. Yes?
Yes.
That's all I got for you. Thank you.
Do any of the jurors have a question for Mr. Odell? Okay.